never slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast, I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want.
All right, welcome everybody. So you just saw the latest update from the Monroe County Detention Center. That is the latest mugshot of Tyrone Tucker. So I'll show it again here. And you're also going to see an update as well. And we've got a lot of things to update tonight. This is not the major update, but this is updated now. As you can see, they've put the reason for the arrest, conditional release violation. So they have listed that on there. His homicide bond is now set at $2.5 million. His the rest of his charges are all at $200,000 a piece. So some crazy stuff. So let's see who we got here. So we've got Flash Fan 85. Welcome. Thank you, Flash Fan Sarah. Welcome. So I appreciate everybody. And I apologize for the late start. I was actually literally getting ready to hit start and my computer started an update. So, it was a little bit strange, when that happened. So, so a couple of things we're going to talk about here before we get started in with the major Ty Tucker update and information. So first off, I wanted to give you guys a little update on where things have been. We didn't get day 14 in yet of Karen Reed. That is still an outstanding episode. I've been on the road. I was traveling. My son had a state track meet. So I was on the road traveling from like Thursday to Saturday for that, and then got back in town. And then my son was also today had his graduation from high school. So been very, very busy. And on top of that, when I got back into town Saturday, my 4-year-old got very, very sick with an ear infection. Ended up, it's just been a tumultuous weekend. So hence why I'm starting so late, because there is so much to get updated on that we need to go over with the Ty Tucker case. But a lot of things I was going to talk about. Some things have developed, and we can talk about outcomes of them. There, one of them in particular being the Travis Johnson situation. But anyways, we're going to get into it all. We're going to talk about it all. There's a lot of stuff. So as you guys saw, Tyrone Tucker is officially booked into the Monroe County Detention Center. So, one of the concerning situations here with this, Ty, when he was on the show 2 weeks ago talking in my chat, we were talking about on that show the potential concern about whether or not Tyrone Tucker will make it out of this situation alive. He really genuinely expressed to me. It's why we went over in that show that evening. Oh, thank you, Sarah. I appreciate that. It's why he genuinely was concerned regarding his safety when he's going to be housed in Monroe County. Now, he was in Oregon. It appears he was flown in, because I was told, I guess it was Friday uh, during the day that he was en route, that he'd been taken and left Oregon. And then next thing you know, I'm also told again, hey, he's arrived. I go on and check it out. And at that point, they didn't have the mug shot up. But then, he's been in the Monroe County Detention Center since Friday night. So something we got to watch, something we need to make sure they know we're watching. Now, uh, another thing of interest is apparently Colleen Dunn is bragging about the fact that Tyrone Tucker is now back behind bars. Now, Colleen Dunn, who is Colleen Dunn? Colleen Dunn is the prosecutor, the assistant state attorney who had a 2-year suspension of her law license due to misconduct in this case and misconduct in another case. But she is someone who attempted to try to get a jailhouse snitch to implicate Ty. And the scheme was caught. And in another case, she did the same thing. She got caught in that case as well. And in this case, what I want you guys to understand, the reason why it's kind of in a way, it's a circular situation where it's like we're back to the beginning now. The reason why Ty was granted bond, okay, the whole reason why Ty was granted bond, and a lot of people don't know this, is because they had filed a motion to disqualify Colleen Dunn from the case, okay? And they were going to have a full out hearing. And in that hearing, they were going to get into the Naheem Jackson situation. It's something we've yet to discuss because, again, as many aspects of this case, it's a lot of information. It's pleadings, it's things we have to read, and there's so many moving factors. But the Naheem Jackson situation was this. They essentially attempted to move Naheem Jackson into his cell or cell block, and effectively they moved him in. Naheem Jackson gave a statement to Detective Pitcher, and there was another officer that was handling him. And essentially, Naheem claimed that Tyrone Tucker had confessed to the crime. It was the facts he gave were absolutely not in line with the evidence in the case. One of them being he claimed that Lauren Janae set this whole thing up, which obviously she wasn't even involved in the picture of this thing prior to that. But essentially, Colleen Dunn attempted to hide the fact that Naheem Jackson had a relationship with the Monroe County Sheriff's Department, that he was a paid asset of the Monroe County Sheriff's Department, and she lied in open court to the judge. She hid this, and ultimately, in the first Arthur hearing, which an Arthur hearing is basically a bond request hearing. It's named after a case that gives a defendant a right to have a full hearing in any case, whether it's a capital case or not. They have a right to have a full out hearing to discuss bond. In that hearing, the case was falling apart. The DNA report had come back and it wasn't favorable. They were not having any cooperation from the other witnesses. So when they had to come to this hearing to make a showing of evidence, they had nothing. Bring in Naheem Jackson. Now, at this hearing, it allows hearsay, meaning they don't have to actually bring witnesses in. So they allow the investigating officers to come in and testify to what witnesses will say, and to the evidence that's been collected over the course of an investigation. So in this hearing, Pitcher came in and testified, and Colleen Dunn came in and told the court that Naheem Jackson had been in the same cell block as Tyrone Tucker, and that he heard Tyrone Tucker confess to this crime. But they also said, in Colleen Dunn held out to the court, that the circumstances of this confession was that Naheem Jackson had no association whatsoever with the Monroe County Sheriff's Department, that he was a good Samaritan, that he was a prisoner who was just happened to be in the same cell block as Ty, and Ty was bragging about what he'd done in this case. Of course, it later comes out that that's not the case at all, that he was intentionally moved, that Colleen Dunn, who had a history of using jailhouse informants, had intentionally moved him into the cell block with Tyrone Tucker, knowing that he was being paid by the Monroe County Sheriff's Department. And on top of that, had said that if he went in and got a confession out of Tyrone Tucker, she would see that his case that he got probation on the case he was being held on. And that's exactly what happened. They moved him in. He came out. He goes and gives a statement to the police or to the detective in the case. It says, this is what I heard. And it was completely not even based on any level of fact. It conflicted with the evidence. But the important part here is she tells the judge in open court, effectively lying to the court, saying, hey, we have no knowledge that he has any association beyond just being a good Samaritan. Well, as the case progresses and as the IA investigation progresses, because of Tyrone Tucker writing a letter to the judge and claiming that there's misconduct in the case, that he's innocent, that there's no evidence, and certain pieces of discovery gets released that trigger that IA investigation. As that investigation proceeds, they learn about this misconduct. They learn about the fact that Naeem Jackson is actually a paid informant, that she knew this, that she lied to the court. So to cover that up, this is why they were filing a motion to knock her off the case. And then because of the fact that the original Arthur hearing was tainted, they were asking for they got a second Arthur hearing. And it was basically, if they would have gone forward with this case and put all of this evidence on the record, she would have probably been disbarred for life and never got a chance to get her law license back. Hence, Dennis Ward steps in, reaches out to Ty Tucker's attorney and says, we don't want to crush her. We'd like the opportunity to let her step off the case. We'd like the opportunity for her to not have to go through this hearing, and that this evidence never gets before a judge and never has to be ruled upon. Therefore, it never becomes part of public record, and she will agree to step off the case. And on top of that, she was already in trouble for misconduct in another case where she had misused an informant, and on top of that, she was in trouble for attempting to block Ty and Lauren Janae from getting married. And they said, what we will do is we will agree to a bail package. And that's when they worked out the $2 million original bail package and said, we will do the unprecedented thing in a capital case and give Tyrone Tucker bail. And, to essentially save Colleen Dunn from being disbarred. So they do that. And he gets out. It's funny that she serves her 2-year suspension. She gets rehired to the state attorney's office, and a week after she's rehired, they file a motion, or they file this paperwork, and Ty Tucker ends up having his bond revoked, and he's back in jail now, and she's back at the state attorney's office. Now, is she back on this case? Not to our knowledge, but is she probably behind the scenes working on the case? I think we can confidently say absolutely. So it's kind of like a 180, a circle, just going right back to where we were in 2019. Colleen Dunn's back. The suspension is served. Tyrone Tucker's back in jail. And here we sit on the cusp of his next trial. And let me tell you, we're going to get into some things here that's going on here. And we're going to get into the tragedy that is this case. That is the tragedy of Tyrone Tucker representing himself. Although he did a competent job, and again, he did a somewhat competent job. In another episode, not this episode because it will take too long, we are going to go through and I'm going to play and we are going to watch the closing arguments in that case. I think that is a great place. I agree with you, Sarah. I agree with you. Sarah asks, how in the world was she able to be rehired? I'll tell you how, because Dennis Ward liked her. She was Dennis Ward's hired gun. She was Dennis Ward's bulldog, and she was a very successful prosecutor from the sense of what they consider a successful prosecutor is. She went in and she got convictions. She went in and she was willing to do whatever she needed to do. She was willing to get her hands dirty. But, um, you know, but we are going to go through and watch the closing arguments of the state. We're going to go through the lies, the outright lies in their closing argument. And then we're going to go through exactly why. Look, listen, Ty got himself a mistrial. How you doing, Cam? How you doing? Welcome, sir. And we're going to go through, uh, and we're gonna go through exactly. And again, we're not doing this tonight. This will be a subsequent episode down the road. But it's really key as you go back. I've watched those closing arguments multiple times, and it's he should have won the case. He should have won the case, but he did not close strong. He let them get to him. He let the objections get to him. And the biggest mistake I think he made, in my opinion, is when he had an opportunity. When he was standing in front of that jury, and he told him, "It's not my. I'm not going to tell you what to think. You know, you need to." And that was the wrong thing to say. The whole purpose of him representing himself was to be able to tell the jury, "I can tell you what to think, and I'm going to tell you that I'm innocent." And an innocent person is going to stand in front of you and say, "I'm innocent. Find me innocent. I know I'm innocent. I'm here standing in front of you because I have, if I had a attorney here, the attorney would be telling you their opinion. They don't know what happened. I know what happened or what didn't happen. I don't know what happened at the treehouse, but I know he is innocent." Flash Fan 85. Let's get the question up here. Do we know if he has an attorney yet? He does not have an attorney yet. And here's the situation. He doesn't have the ability right now to hire an attorney. He has no money. Okay. Lauren Janae is not willing to show out any more money for attorneys. You can read between the lines on all of that because they're separated. They were living separately. There is a ability for her to only spend so much. And she currently, that's another part of the update we're going to talk about. She has a civil case she's actively having to fight herself. She's being sued by Penny Phelps. She's still spending thousands and thousands and thousands of dollars litigating that. And there's a hearing. It's a 38-minute hearing that went before the 11th Circuit Court of Appeals. I have the tape of the hearing. We're not going to necessarily listen to it tonight again just for time, but it'll be another episode that we're listening at. It's actually quite interesting. But Ty's going to have to get appointed counsel. Now, one of the big problems is, well, yeah, they're not divorced yet, but legally entangled. And that's the problem. I mean, when they're not, even though they're not divorced, he still technically financially would not qualify for appointed counsel. So then it comes on to, is there a way to raise money for him to get an attorney? Can he, should he maybe consider going the route of a divorce at this point, and putting that in motion so that he can be in a position? And, he may not like that idea because obviously Lauren Janae's presence in this case is what brings the attention, the media attention into it. And hell, who wants to have to say I'm getting a divorce? But, in this case, it would give him the ability to get an attorney. But at the same point, too, remember, Ty doesn't necessarily feel he needs an attorney. This was when he, there was a multitude of reasons why he went per se, but I believe one of the main ones was they ran out of money. He basically said, "Listen, I don't need a good attorney. I can do this myself. I know the case really well." And, it was a great plan. But the problem is he's got to come in differently and he's got to be willing. This is not like the problem that I saw in that case. And I remember thinking about it. And as I've rewatched that closing argument, the effectiveness of him representing himself is him being able to stand before that jury and tell them, "I'm innocent. I'm innocent," and do it strong and do it confidently. But if you don't have the confidence to stand in front of that jury and say, "I'm innocent. I am innocent. You find me innocent because I'm innocent." Like this cases is about, these criminal cases in the United States are not about guilt or innocence, true guilt or innocence. They're about whether the state can prove the case. The state has the burden. But I have the unique thing to tell you: be comfortable finding that the state didn't meet its burden, because I'm telling you I'm innocent. Now, you may not be completely fully convinced of that, but you don't have to be. But I'm telling you I am. I know for a fact I wasn't there. Why wasn't there tape of me walking back? Why wasn't there tape of Travis? Where's the tapes? Where's the CVS tapes? Where's the evidence? Where's Phelps? Where's Pitcher? Where are all these people? That's reasonable doubt. And that reasonable doubt is enough for you to find me not guilty. But here's the best part about it, guys. I can tell you right now, be comfortable voting not guilty, because I'm actually innocent. And that's why I'm standing here, because I'm wanting to tell you personally, to your all's faces. The problem is, instead, what did he do? He said, I'm not going to tell you what to decide. What? What do you mean you're not going to tell me you're not going to tell them what to decide? That is exactly what you're supposed to be doing. You're supposed to tell them what to decide because you're innocent. But anyways, that is one of many reasons why he should have an attorney. But whether he will or not, I don't know. But I hope that when he gets back to court, if he doesn't have an attorney this time and this go around, that he absolutely 110% comes in stronger this time and goes after the state, and uses the one advantage that he has, and that is that he is an innocent man. I mean, that is that's the advantage in this case. That's the secret sauce that he's going to have. So he's got to use it. Now, before we get into, again, I know I've given a long preamble here and talked about some background things, but before we get into the first topic, I want to also explain something else and go into something else with you guys as well that's just channel related while I have everybody's attention. So we have a new channel. I'm announcing that. I put up a spot in our community section, but I'll talk to you guys about it. So right now, do me a favor. There is a link. I don't know if the stream's coming up. I was trying to dual stream. It looks like it's not up, but there's a link that'll take you over to the stream and at least get you over to the channel, and it's called Justice Watch. Now, what is the purpose of Justice Watch? Why did we launch the second channel? Number one, obviously, I can't monetize any more channels for until the 90 days is up. But what I want to do is have this channel, Justice as a Process, is going to be about current cases. It's going to be about watching current cases that are going on, covering things like the Ty Tucker case. Oh, thank you, Sarah. I appreciate that. Justice Watch is going to be watching past cases. Like right now, the inaugural case we're covering is the Adelson case. Now, I was attempting tonight to do Justice Watch Live. As you can imagine, we've named it Justice Watch. Justice Watch Live is the official show that goes along with Justice as a Process and Justice Watch family of channels. That's our official show. That's where we go live. That's where I interact. That's where we will talk about ongoing cases, past cases. So my hope was we'll figure out how to do it. I don't know if it's something about the key, but according to what YouTube's telling me over there. But the goal is to give a platform where we can cover both sides. So that way it's not overlapping as much, and we can have, one area where we're going to be going in, and there's a whole bunch of cases I've got access to that we're going to be covering. So the Adelson case is where we're starting. It's something I haven't covered over here. So, I covered it a little bit over here, but we're going to cover it as a past case. Now, when Donna Adelson gets tried, that will be covered over on Justice as a Process, because that's a case in action. But the Charlie Adelson case is a past case, and we're going to be covering, like I said, there's a whole bunch of cases that we've got that we're going to be doing. You're going to see shorts over on both sides covering those cases and covering those things. Yes, I will be showing classic cases from the 90s. We're going to cover things like the O.J. Simpson Vegas case. We're going to cover the O.J. Simpson case from the 90s, where we'll be showing different things. We're going to show the Menendez. I mean, there's a whole bunch of stuff that I've got access to right now that made me decide to launch it, because I thought, well, I could try to do it on Justice as a Process, but that's my daily show where we're going to be covering, like we're covering Karen Reed right now. But Justice is the Justice Watch is going to be more of a we're going to cover it. We're going to show old cases, and then we're going to talk about it. I will appear. I'm not going to be necessarily sitting in the box over there all the time, because those will be shown in the after hours. But we're going to be doing that. So yeah, let me know when that case is scheduled, Cam, because yes, I want to cover that case. But it's like cases like that, we're going to continue to cover cases that are in the news. Obviously, I can only cover so much, so I'll pick a case and then we'll stick with it. It's like the Karen Reed case right now. I'm a little behind on it, but we're going to get caught up, because the good news is we only have, I think the Karen Reed case goes into recess on Wednesday. So even though I'll be a little bit behind coming into it, I can get caught up, and there's a lot to talk about with that case as well. But and we'll continue to do things like, Justice as a Process will be the spot when I'll do interviews and things of that nature. That's going to be, like I said, the main spot still, but Justice Watch. And maybe after the 90 days, if there's an issue after the 90 days, I might, and I get Justice Watch monetized, I might flip that and say, well, we're Justice as a Process will stay unmonetized, and we're going to, I appreciate that. Yes, I will, Sarah. Thank you. Yes. It's going to be definitely uber busy is an understatement. And then on top of that, of course, my wife is pregnant, and we're going to be having a child in August. So our fourth child, I'm going to be sending my high schooler to college, and we're going to be doing all that stuff. So it's going to be a lot of balancing, a lot of different things. So I will absolutely, keep you posted. I appreciate that offer, Sarah, because it's going to be an undertaking. But once we get all of this going, I think it's going to be a really nice little deal that we can have here, because that's the whole point here, is just to be able to watch Justice as it unveils now and goes forward. Yes. Oh, thank you, Sarah. Appreciate that. Yep, we got, like I said, it's we've got one going, starting life and going to the next level of life, and then I'm going to be starting one that's going to be starting right from the ground floor up, and getting a chance to do it all over again, and undo some of the mistakes I made in the first 18 years. So, do it all over again. But all right, so let's get into the business at hand. Let me get up the first document. So the first thing I want to do is go over the update here on Travis Johnson. So, as you all may have heard, Travis Johnson absconded. Okay. However, there's a major update on this. Let me share this. I don't know if anyone has seen this or knows this, but I now know where Travis Johnson is, and he has been found. He is going to come to trial. Anyways, without further ado, let's get into this document. So this is a motion that was sent to me, and I appreciate that it was sent to me. And this was filed. Let's see here. It's a 2-page motion. This was filed. I don't know. That doesn't look like it has a date on it. This was filed recently. This was filed. There's got to be a date, right? Oh, 17th day of May. So this was filed on the 17th. We're going to read it together. Comes now the state of Florida by and through the undersigned assistant state attorney. And I want you to keep in mind when we read this, guys, I want you to keep in mind the fact that Ty Tucker, of course, think about what they're doing for Travis here in this case, because Ty had a warrant issued, Travis has a warrant issued. Think about contrast how they're treating the two gentlemen, and consider the fact Ty Tucker's completely innocent and Travis Johnson is the guy that's actually guilty. And they know this. And this is what they're doing here. Comes now the state of Florida by and through the undersigned assistant state attorney and files this motion to quash the VOP warrant and to convert the defendant's probation to administrative in an instant matter. and as grounds, therefore, states as follows. The defendant in the instant matter was charged by way of information with robbery with a deadly weapon masked and aggravated battery with a deadly weapon masked. On May 6, 2022, defendant pled guilty and received 4 years Florida state prison followed by 5 years of probation. As part of his plea deal, the defendant agreed to provide substantial assistance. The defendant has been in constant communication with the Office of the State Attorney while on probation. The defendant informed the state that his father has become ill and has no one to take care of him. The defendant requested from the state that he be allowed to relocate from Monroe County to Texas in order to take care of his elderly father. On May 15, 2024, the state of Florida learned that a violation of probation warrant was issued for the defendant. The violation alleges that the defendant failed to report as directed and is in arrears on monetary costs and supervision. In his communications with the state of Florida, the defendant was evicted from his home. The defendant has been living in Wisteria Island and is currently homeless. The state of Florida, by and through undersigned counsel, is seeking to have the defendant's probation be converted to administrative so that he may care for his father in Texas. Moreover, the state of Florida would be respectfully seeking that the VOP warrant against the defendant be quashed and violations be dismissed. Wherefore, the state requests that the court issue an order quashing the VOP warrant in an instant matter in order that the defendant's probation be converted to administrative. So there you have it, guys. Mystery solved. He's in Texas. He's taking care of his father. But I want you to consider here, all right? This is the guy, okay? This is the guy who's one of the two who actually did this crime. He hasn't paid his monetary costs. He hasn't been compliant with his probation. He has reported, at least, I guess, to the state attorney's office. He leaves and flees to Texas. Apparently, he must have told the state attorney's office. Now, state attorney's reaction. They're asking to quash, which means they're asking to throw out the warrant, and they're asking the court to put him on administrative probation. What that basically means is he will have no need to report. He will not have to report where he's at, and it will be essentially like having no probation at all. Unless he gets arrested for a crime and the state of Florida finds out about it, he essentially can do whatever the hell he wants. Okay? Now, contrast this, and we're going to get into the actual circumstances of what they say happened. But Tyrone Tucker allegedly misses a urinalysis, right? And they not only violate him. How you doing, Brittany? Thanks for stopping in. They not only violate him, but they go and pick him up at the airport, knowing that he's on his way back because he reported that to the judge, to the clerks, to the papers, to everybody. And you're going to see how they try to represent this in a minute. We're going to get into the documents that I have. And they throw a $3.1 million bond, as you just saw, $2.5 million now on the homicide, and then $600,000 on the 3 other charges. And they have him back down in Monroe County again, and they're going to hold him now to his trial. Okay. Whereas, and Tyrone Tucker didn't flee anywhere. He didn't do anything. It was a mistake at the testing center. Maybe he was a little late. Okay, but he certainly did not pay something. He didn't ignore his need to pay the monetary costs associated with probation. He didn't just ignore the probation and leave and flee to another state. No, he didn't do any of those things. But this guy does. And what happens now? John Travis Johnson, the state wants to reward him by quashing or throwing out the warrant, and then taking his probation and removing any accountability in his probation. And this is a guy who did the actual crime, who was there. Okay. Remember, he was there. He attacked Todd O'Quinn. He was part of the attack on Todd O'Quinn, and quite possibly is the one who stabbed Matthew Bonnet. And this guy, the state of Florida is okay with allowing this man to do 4 years in jail. He didn't even do prison time. He was in the Monroe County Detention Center awaiting trial. And then on top of that, he gets out. And because he's willing to testify against an innocent man and get an innocent man railroaded into prison, the reward is we're going to convert your probation to administrative probation and let you walk. While at the same time, at the same exact moment, they're throwing the cuffs on Ty Tucker. They're picking him up at the airport when Ty Tucker is coming to Florida, not leaving Florida, not trying to get out of his responsibilities. He's going to Florida to turn himself in. And they decide to lock him up and pick him up at the airport and then throw him and hold him on a $3.1 billion bond or $1 million bond, not billion. I apologize. That's the state of Florida in this case. That's their version of justice. That's what's happening with John Travis Johnson. So he's going to be there at trial. Don't worry. He's coming back to trial. But we're going to get into some things here that is really sad. The tragedy of this thing, because Ty was trying to handle this on his own. He created a bigger mess for himself, I believe, in all of this. So, good segue here. We're going to talk about now, since we were talking about the differences here, let me pull up. Let me figure out which document is which here. All right, come on, documents. Let me see if we got. Nope, it's just a white screen. That's what I thought. All right, I don't know why these documents are having problems, but let's see here. Thank you, Brittany. I appreciate that. Appreciate that a lot. I appreciate you watching and participating, because it is important what you being willing to watch this and become informed about this is equally as important as me covering it, because it is something that is absolutely, it is an injustice. All right, I've got to pull up. I apologize, because I had these documents pulled up, and for whatever reason, they didn't hold. All right, so let me go back into the Monroe County Clerk of Court here real quick and get these documents up. It's funny how when I do these lives and I get these strange technical difficulties. It's like they don't want me to show this stuff. All right, let's get them up here. Hopefully it'll let me back in with no problem to get to my documents. Yes, it did. All right, good. All right. I just got to wait for them to load. But essentially what we're going to be looking at here is we're going to be looking at the actual documents that describe what happened in this case. And there's two violations that they're coming after Ty with. Two violations that they're coming after Ty with. And we're going to go over them. And you're going to see just how dirty these guys are, because this is some dirty stuff. The way they just literally lie with impunity. They don't care. They're willing to lie, and lie again. So here's the first document up here. Let me get, yes. All right. So this deals with, hold on here. Let's go in. All right. So this document here, let me get it zoomed in a little bit for you guys so we can see it pretty well. So this is the first non-compliance memo. So this is what was sent to James Morgan. And we're going to talk about what we know to be, what I know to be true, at least based on, well, I don't know it to be true. What I've been told is true. What we were told is true from Ty. And we're going to talk about what they included in this. So and what I've also been told through investigation, talking with the testing site, what the testing site says actually happened. So here it says, above named defendant was released on pretrial supervision 11/6/19. Failure to appear for random urinalysis on 4/10. So they popped him for 4/10. So let's look at what happens here, right? Because I want you to notice they don't talk about the fact that on 4/11 he went in and he got tested and he passed that test, which we know to be true because Lauren Janae went down to that center and could talk with those people and has statements from those people, which I'm told will be able to be brought into court and will be able to be used by Ty to contest this failure to appear issue. But you're going to see they doubled down, and you're going to see what they did to him. And listen, we were involved in knowing the second part of this that I'm going to show you as being absolutely a lie. But anyways, let's read this. Defendant contacted pretrial services in the evening on 4/9/2024, stating the lab where he tests for alcohol had issues and would not permit him to test. He stated he arrived at the lab around 4 p.m. The GPS monitoring shows he did not arrive until 4:46 p.m. 4/9/24 test was excused, and the defendant was granted permission to test on 4/10/2024. He was specifically instructed to arrive earlier. Once again, he arrived late and again missed the test, stating he encountered the same issue. Now, I want you to notice something that's missing here. On 4/9, they actually put the time, 4:46. So what exactly is the time? Why did they not put the time? That would be one of the first things I would want to know here. If a hearing comes up, if this gentleman gets called, which he will be called, he'll have to come in and testify at the actual hearing if Ty challenges this. But what's the time? So when you say earlier, was there a specific time given? And did he come in again at 4:45? Was he there at 2:00? What exactly happened? But anyways, encountered the same issue at the lab. When asked to explain what the issue was, the defendant stated that it was a computer issue. He also stated he knows he should have arrived earlier, but fell asleep and was feeling ill for the past 2 days. Previously, he did not mention anything about feeling ill. The lab was asked why the defendant was not permitted to test on 4/9 and 4/10 and stated that his registration had expired by the time he was served after waiting in line 10 to 15 minutes. Defendant was informed that under the circumstances, he missed the test on 4/10/24 is non-compliant. Request of affidavit of violation. Okay, so that's what he got. That's what he got violated for, guys. There it is. Now here's what we know. Because Lauren Janae went and talked to those people down there. He was told that he could go back on the 11th and test again. That's left out of here. He showed back up on the 11th. He tested, and he tested negative. He showed back up early on the 11th and tested negative. Why is that not in here? Why is that fact? Now, I understand some are going to say, well, it's a violation. It's a violation, yes. But should you be brought back in handcuffs, picked up at the airport trying to go down to Florida to resolve this thing, and then held on a $3.1 million bond over this after 5 years? Okay, there was an issue back in the fall, and you know what? He was called to court. What should have happened here is he should have been brought into court, brought in by the judge. But we're gonna watch something else to end this thing today. Something that we now have. You know, they always say hindsight's 20/20, and we're gonna relook at something, and you're gonna see what I want your all's opinion when we watch this. If you see what I see here, because again, hindsight is 20/20. When you look back, when you now have circumstances and outcomes like this. All right. So, this is wrong. And again, I understand he's out on bond. It's a serious charge. Many would say he should have taken, but there's no reason why you would violate his bond when he showed up on the 11th. There is just it just makes no sense. Exactly, and it also exactly Flash fan, and thank you, sir. But yes, it tells you there's other motives. Okay. It tells you there are other motives behind the violation. So, it tells you that this is not truly about uh, trying to do this in a just way. This isn't about justice. This is about this judge, as I said from the beginning, carrying the water of the judge of the previous judge. He, in the fact that he was appointed by that judge, that he holds that judge in high regard. Ty was coming after that judge. Ty was claiming that judge was in on a conspiracy. Ty is attacking. Ty's going to be, remember, Ty was planning to file a 100-page motion to reconsider dismissal. He was going to be alleging that, he was going to be alleging that Judge Jones and Mansfield and all, again, that they were violating his due process rights, and that this, that they had allowed for John Travis Johnson to come on and give perjured testimony. That was one of the basis for the dismissal, and one of the pieces of evidence that can show that is the motion to suppress. And this judge doesn't want that to come out. This judge came on this case with a desire to hide it. It boggles the mind. And yes, it is a personal vendetta, because what this is they want Ty Tucker to plead guilty and go away. And they're letting him walk. It tells you everything you need to know when they're willing to let him walk he would have been able to just go off of his pretrial release and go on into the sunset. They don't want to have any accountability for their actions in this case, and they want to be able to walk free, and they want to be able to protect their own, and they want to be able to move on. He's not letting him do that. He's refusing to go away silently, and as a result, he's potentially going to pay a tremendous consequence, and that consequence could be his life. Now, let's get into it. Gets even more egregious, right? We look at that with what we know, with what I'm telling you I know. But listen, if you were on this channel, if you were talking with him, absolutely, Flash fan, I agree with you 110%. We can all say some of the facts in this affidavit or in this non-compliance. We know some of these things are not true. So anyways, check this out. So they're serving him with this as, in addition to the urinalysis miss, he's also getting, and again, this is a concern here because they're essentially, this is the setup. They wanted Naheem Jackson as evidence of guilt. This is the second setup where they are going to attempt to try to insert this into the trial and say he was fleeing. Check out this, guys. This is egregious. Franklin Tucker violated his pre-trial conditions of house arrest by leaving his residence on 5/3/2024 at approximately 3:45 p.m. Pacific time. He did not first obtain approval from his pre-trial officer prior to leaving residence. This infraction occurred after the offices of pretrial services had closed. So I want you to consider how they're trying to scheme this. They're making it sound like he waited until pretrial services closes, he leaves his house, and he heads, well, let's finish this out. Defendant arrived at Portland International Airport at approximately 4:20 p.m. Pacific time, and Portland law enforcement and state attorney's offices were notified of the defendant's location. So he didn't take the ankle monitor off. That's how they knew where he arrived. That's how they knew he got there, right? But how are they trying to frame this? They're trying to frame this that he waited intentionally until pretrial services was closed and then tries to get to the airport. Okay, we know this isn't true because the night before he did that, he was on this show, Justice Watch Live, talking in the chat. I still have a copy of the conversation. Well, obviously, I have the video of it, but I also have a copy of the conversation that he was having a conversation with me through Facebook Messenger. He and I were talking back and forth. You hear me talking to him because he was watching the show, and we're talking about how he's heading back. He's planning to head back to Florida. He told a newspaper that. He's telling everyone that he's heading back. In fact, Lauren Janae made 4 different tickets for him. 4 tickets that day. because he was trying to get his motions filed to be prepared so he could file some of the motions prior to having to go to jail. And he wanted to have motions pre-prepared to be able to get filed when he got down there, because he knew he might not have access to his computers and to everything that he needed. So he's trying to get things done. He was running late-ish, and she ended up rescheduling his ticket 4 times. And again, I listen, he should have contacted pretrial services. He should have contacted his bail bondsman. He should have got an escort, just like I said. Hold on. Excuse me. It's allergy season. I apologize. But still, they knew he was coming. And the way they're trying to portray this in this violation document is completely dishonest. And it's completely disturbing. So, and that bothers me a lot. So let's continue reading here. Portland Airport Police began searching for the defendant at the airport, and he was taken into custody at approximately 7 p.m. Portland law enforcement notified pretrial officer and confirmed that the defendant had purchased an airline ticket, destination unknown at this time. So, do we really believe that? Do they really expect us to believe that the airline police confirmed he bought a ticket but didn't see where it was going? Do we really? That's a lie. That is a flat out lie that's telling you they were trying to make it look like he was fleeing. Oh, mine are too, sir. Mine are too. Portland law enforcement notified pretrial officer and confirmed that the defendant had purchased. It is noted that the defendant, and look at this, look what's added in here. It is noted that the defendant had been informed of signed warrant and bond of $3.1 million on 5/1/24 by email. Defendant was also informed that a warrant had been issued for his failure to appear for random urinalysis on 4/10/2024. Defendant has previously been told that he was non-compliant for failing to appear for a random urinalysis on 4/10/24. They're making, yes, that's what they're doing. But guess what? He wasn't. And Lauren Janae has the evidence. And you're telling me they were able to confirm that he had a plane ticket, but they didn't know where it is? Come on, doesn't even make sense. But they're trying to do that because, see, just like in their Crumley case, they have a right to use fleeing against him as evidence of guilt. It is not possible to have, no, Sarah, it is absolutely not possible for that. And he didn't have a destination unknown ticket. And luckily, Lauren Janae has the evidence. In fact, there are witnesses I know of. I'm not going to get into all the facts of what I know on that. But I'm telling you, there are credible people who knew he was coming, who were planning to meet him and planning to get him to surrender. Now, the problem is there was a misunderstanding. The bail bondsman had reached out. They thought it was a previous bail bondsman. That bail bondsman actually told them, and again, maybe it was a setup because they were worried it was a setup. But that bail bondsman actually is the one that they relied upon when they said, you don't have to report anything to pretrial services anymore because you're not technically under pretrial services anymore once they issued that warrant. And yet, so Ty didn't believe that he needed to report anything or say, hey, I'm leaving, or let me get clearance, or do the things he would normally do. He believed, even though he still had the ankle monitor on, he believed that it wasn't even being monitored anymore. Now, I attempted, and again, that part of that conversation online, there was other conversations to say, no, that's not what you need to be doing. You need to be contacting the bail bondsman, get an escort down there, and turn yourself in and call the judge's office, call the clerk's office, give them a copy of your ticket, call pretrial services, give them a copy of your plane ticket, make it as clear as day that you are traveling to Key West and you're going nowhere else so that this couldn't happen. And this is exactly what happened. And they are going to try to make it look like Ty Tucker was fleeing. That is their angle. That is going to be, their case is going to consist of now Ty Tucker's fleeing, attempted to flee. He got locked back up. He also, he also allegedly told Paula about blood on a knife. We already know they're going for that, right? And on top of that, they're going to make it look like that Ty Tucker attempted to buy Paula's testimony, because they're going to. The reason why they want Ty Tucker's testimony is because they believe that opens the door for them to bring that back in, because he's already testified. Oh, absolutely, Flash fan. Yes, he can. Yes, he can. And that's what he's going to have to do. But it would be better for him, to be honest with you, just have an attorney handling this, because that way they could make sure everything gets called. But it's going to be very difficult. Think about how difficult it's going to be for Ty Tucker to be getting subpoenas, to be getting in touch with witnesses, to be trying to orchestrate all of this from the Monroe County Detention Center. It's going to be damn near impossible. And then he's going to have to try to file these motions and try to figure out the law, and he's going to have no access to anyone. He's not going to be, again, there's another reason why they pulled him out, because they believed, obviously, there were inferences that during that trial that they were saying Ty Tucker's getting help, Ty Tucker's getting information, Ty Tucker. And again, he had people that were contacting him. He had people that were trying to give him tips and help him out. And they're pulling all of that away from him. So when he goes to trial this time, he's not going to have a phone in that courtroom. He's not going to if they don't give him a hybrid defense, which I don't think they're going to, he's going to be sitting in that courtroom. He's not going to be going back to his attorney's office in the evening time, Jerry's office, and sitting there talking with him and getting tips from him. He's going to be on his own. So it's going to be, they got plans to do this far differently than the first time around. And that's a concern. That's a concern I have. And it's hopefully a concern of Mr. Tucker's, because he needs to make sure that he has legal counsel, and whatever needs to be done to do that. That's why if he has to divorce his wife, they can figure out their relationship when he's a free man. It's a procedural thing. I had an aunt that did it for purposes. It wasn't for that purpose, but it was for other reasons that were related to Social Security and benefits and different things. And they had to get divorced, but they're still together as a couple, but they're just not legally married, because it just isn't what made sense. And it's the same thing that can happen here. So obviously he's not going to be able to hear this. He's sitting in the Monroe County Detention Center. But if he has to do that, but the thing I hope that resonates with him is, and hopefully Lauren Janae's listening to this, maybe, or she hears this, she needs to do that and talk with him about that, and get a quick divorce if it's possible, and allow him to get appointed counsel, since she's not able to afford to do to pay. And again, the bad part about she brought a lot of good, in the sense that she brought attention in, but the problem is right now, an attorney that comes into the case is going to expect to get paid, and they're going to expect she's got money, because what have we all heard? She's a millionaire. She's a millionaire. She's a millionaire. Well, she might be a millionaire. She might have been, gotten $1 million, but that doesn't mean she has access to millions of dollars in liquid funds to be paying legal fees, so it's far different than what it seems when you hear these news reports where, this person's got all, listen, there's been a lot of legal fees paid. There's a lot of overhead expenses, and this wasn't a scenario where she's getting continuous payments from CrossFit. She got a one-time lump sum payout. So that money's got to be managed. That money's got to last a lifetime. So, look, but the issue at hand is that doesn't help him apply for appointed counsel. So, and the problem is right now, anybody that comes into the case is going to look at it and say, well, your wife, you got money, you want to help your husband out, you need to pay, you're going to pony up. Well, best thing to do at this point is, you brought all the attention to the case, you've done everything you can, step away and separate and say, for now, we're two separate entities. Ty is responsible to find his own counsel, and as a result, can get appointed counsel, hopefully. And there should be, in my opinion, still good attorneys out there that would be willing to get appointed, so they get their expenses covered, they get a little money, And then they get the publicity of this case that comes in, because this case is going to still generate publicity, big publicity, because people are already aware of it. People are already aware of the circumstances. People are already aware that he represented himself, and there's already an online presence for it. And that's what needs to happen. So let's see here. So the next step we're going to do, that we're going to close out the show tonight with looking back. We've gone through. You've seen all these different things that have come up. We've seen what the judge has done in this case, and now we're going to go back to a hearing in March. Okay, let me get this queued back up. I apologize. I knocked it out. We're going to get back to this hearing. We're not going to watch the whole hearing, but we're going to watch this portion, and we're going to talk about it. Because at the time this happened, I remember telling Ty that he should not. We were in contact, and I said, why did you do this? And he even got questioned in the comments of this video. And he didn't understand why it was a bad strategy move to do what he does in this hearing. And we're going to talk about it, because when we look now at what was happening here, and we look at the way Judge Morgan and Mansfield sets him up, I believe they set him up to waive this. And watch how they do this. And this tells you all you need to know about this judge. This judge is doing exactly what I said he was brought in to do. He is walking into this trial, and he is here to basically eliminate the BS, eliminate the delays, and walk Ty Tucker right through this case, waiving anything that gets in the way. In other words, hey, this needs to be done by this date. This is how you do it, Mr. Tucker. Mr. Tucker shows up and says, I don't have it. Waived. Subpoenas run out. Sorry, sir, you're not calling that witness. Oh, you don't? Okay, sir, there is a procedure. Have you looked it up? Oh, you're not? Well, you're representing yourself. You're responsible to do this. We're going to consider it waived. He's not going to delay this thing. That's why he even says in this hearing, Ty's talking about he believes he's going to need more than 10 days. And he says, well, sir, you haven't seen how I do things. We're not going to need 10 days. We're going to blow through this trial in 5 days. We're going to get this thing going, and you're going to either have your witnesses ready or not. The state's going to have witnesses sitting in the box all day long, and you're not going to be cross-examining witnesses for hours and hours at a time. It's going to be, you're either going to know how to ask questions, or you're going to get cut off, and we're going to move on. And again, Ty didn't see any of this coming. He didn't read this judge that way. He, for some reason, thought this judge was a fair judge. And I had, starting right here at this hearing, I had a very concerned outlook with this judge. And when you consider some things, we're going to walk it through. We're going to stop it and start it. I'm going to take you through it. And hopefully, I think by the end, you're going to feel the same way I do looking back at this hearing. All right, let me go into your worst case scenario. If he does not have an attorney, that's why I'm hoping when he goes to trial, I hope there's TV cameras. Well, I hope so too. I think there will be. If they got divorced, would it impact this fight? Yes, absolutely. No time has to pass, because the only thing would be this, Sarah, okay, is if he gets a settlement, right? Or if he gets I don't know, I don't know the divorce laws in Oregon, but if somehow he was getting a stream of income because of his divorce, alimony or something like that, or he got a lump sum settlement, because I don't think they have a prenuptial agreement, then that would potentially affect it. But if he were to get a divorce and he walks away with nothing, and she walks away with her assets, and he walks away with what he entered the marriage in, and they walk away and they do it quick and sign it, they've been separated, so there's no separation period. At that point, he's got nothing. He's got no job. He hasn't worked. He's got no assets. He's got nothing. He's homeless again. He would immediately qualify for appointed counsel. But again, it's all a matter of how quick this goes, because as long as he's with her, he will more likely than not qualify for appointed counsel. And maybe he could, but he would have to, again, and this is something he's going to have to do. The other issue is from my understanding is he has not always been easy to be. He's not always been easy to deal with his attorneys. He kind of has some expectations that might not be in line with what really they should be. And so you're going to also have that, because remember, I was going back through the case record and I noticed that he went through a lot of attorneys early on before Lauren Janae was paying the bills. He'd gone through a couple of people because he wasn't getting along with them, because he wanted things that were not necessarily what the strategy that should happen. Because again, remember, you're not here to prove anything yourself as a defendant. The state's proving something against you. So sometimes it's like you sit and let the evidence get presented and you ask your questions, and you don't necessarily need to start putting unnecessary things on the record or putting up a defense necessarily. And he wants these things done his way. And if it's an appointed counsel, and the lawyer says this is how it's supposed to be done, and you're not paying the guy, or worse yet, he is paying the guy and he says this is what I want, and the defense attorney says this isn't the strategy. And that's essentially why I'm told there was a lot of factors that went in. He wasn't getting along with his attorneys, the previous attorneys. It was a very toxic relationship. There was money issues. There were issues going on. Obviously, they're living separately, so read between the lines. And the result was Ty said, you know what? I can do this on my own. I can do this better than anyone else. So there was a tad bit of arrogance, and there's also a desire, because what he really wanted to do and really wants to do is not just get found not guilty. He wanted the opportunity to really bring a spotlight on the corruption that's going on in his case and the things that were done. Now, yes, Flash Fan 85, he did praise Judge Morgan. And I think it was a really stupid move to do that. But anyways, let's watch some of this.
Because obviously you're making a waiver of this right, okay?
Yes, sir.
Of this rule. This rule requires something to happen.
Hold on.
Apparently, was it as long as I'm willing?
Okay, Mr. Johnson, do you understand that the rule? That's not applicable.
Oh.
But very generally speaking, is the state prepared to proceed?
Judge, we are.
In time period in May, days to conduct the retrial. That is the tentative plan. There's going to be more to follow on that. But first, Mr. Mansfield.
I agree, Brittany.
Is it still the state's desire to retry this case?
Yes, Judge.
Okay. Now, again, it's not final in any way. I think, Mr. Mansfield, you know this. I believe Judge Wilson has a trial that is going that same time period in May. I'm going to have to talk with our circuit court administrator to deconflict of you.
All right, so just to set the tone of what's happening here, guys, to refresh your memories. Right now, Judge Morgan has called this hearing. He's let them know previously that there's a conflict issue, okay? And that's important, because what he's basically saying is that because he worked in the public defender's office, he believes there might be a conflict. Now, he's saying unless Ty Tucker raises that conflict issue, he thinks he's okay to stay on the case if Ty Tucker essentially waives the challenge, because then it's just a matter of whether or not the conflict is so egregious and so apparent that it requires him to recuse himself. So he steps into this hearing basically saying, Ty Tucker, I found this issue. If you want to raise it, I very well will take myself out of the case. But again, what he's doing is he's baiting Ty Tucker to waive that issue and let him stay in the case. And he's also, Ty essentially takes the bait and actually says to him, the fact that you're bringing this to my attention, Judge Morgan, I want you on the case, because Ty's thinking, oh man, this guy's a really great judge. He's unlike Judge Jones. He's actually coming to me with this information here, and wow, he's really being transparent. No, that's not what he's doing. He's baiting you, Ty, and Ty's taking the bait right now. Now, what they're talking about right now is they're talking about a particular rule, and we're going to pull up the rule right now so you guys understand this rule as you're listening to this. It will help you guys to better understand this. This is the rule here. It's Florida Rule 3.191. It's a speedy trial. And what it basically states here, this particular section that they're dealing with is Section M. So let's read them. Because Ty had a mistrial, this kicked into effect. A person who is to be tried again or whose trial has been delayed by an appeal by the state or the defendant shall be brought to trial within 90 days from the declaration of a mistrial by the court. Okay. And this is what they're discussing. So what this means is I believe Ty's date was the 29th. If I'm not mistaken, I believe it was the 29th of January. I could be wrong on that, but it was somewhere around there, which means the state had until the 29th of April. Now, I want you to understand the timing of this. This hearing occurred on March 11th. Okay. So effectively, we are a month and 18 days away from when the state would have had to been prepared to retry him. And they legally had to retry him by that date. Okay. Within 90 days. Okay. Or you're going to see this rule kicks in and you're going to see what happens. There was a lot of flexibility here that Ty could have avoided a trial if he wasn't ready to go. And he could have, of course, waived it at any given point. But if the state wouldn't have been ready to go, if John Travis Johnson's over in Texas taking care of his dad, if we don't even have a judge on the case, none of that's Ty Tucker's fault. And none of that is going to be an excuse for them not to try him. And it would have kicked in here and he would have had the case dismissed with prejudice, without prejudice. And he would have walked away from this case. And it would have been the potential way for the state to basically have an excuse to say, well, we couldn't retry the case because we didn't have access to a witness. We couldn't find a judge and we couldn't get the trial done within 90 days. And he could have walked on down to sunset. But you're going to see at Mansfield and Morgan kind of team up together. And Ty takes the bait and waives this inexplicably. And when you look at the fact that Ty Tucker, for the reason why he waived that, was because he wanted to file a motion to dismiss. He has yet to file that motion to dismiss. Not only has he yet to file that, but it turns out that Judge Morgan ends up staying on the case because at that particular time, if Ty would have filed a motion to disqualify Judge Morgan, then Judge Morgan would have had to step out of the case. Do you really believe that they would have been able to find a judge within a month who didn't have a trial that already conflicted? And again, it doesn't matter. He would have been able to file a motion. Well, we're going to talk about that here in a second, but he would have been able to get this case dismissed. And that would have been the route that he could have gone. And an attorney would have never waived this yet. They would have waited until the very last minute. But Ty clearly did not understand this rule, exactly the strategic way to apply it. And he gave it up. And now they don't have to try him in any particular time. Well, here's the thing, Brittany. I did dig into his background and I missed that article. Now, I was told by Ty and Lauren that they were aware of the article that I put up. But I never found that article. I was looking into him, but that's what I found so weird. I was telling my wife that. I said, how did I miss it? I don't understand. I went and dug into this guy. I'm looking, I'm Googling, and then suddenly his bond gets revoked and I find it. Do you think his bond would have been revoked if Judge? No. See, Judge Jones, listen, Judge Jones had it even. That's the crazy part. Last year, right before trial, Ty failed a test. Judge Jones didn't revoke him. He ordered him back to Key West for a hearing. Ty complied, came back to Key West. They had a hearing. And the remedy, and this is a factor I haven't got into yet, but my read, I'm not a lawyer. I'm reading it as somebody who just has experience with reading cases and having talked about the law a lot with my dad, who's trained me on how to read cases and look at things. But there's clear case law that states that when it comes to bail revocation, when it comes to bail related issues, even something like pretrial release, the last resort is revoking bond and issuing a warrant, right? Because the main factor when you're considering bond is wanting to ensure that the defendant shows up. So him not complying and being late should never have risen to the level, especially if it was a first offense. Now, if it was like, 7 or 8 or 10 times, you maybe you do the unprecedented situation to where you kind of do that. But this was like the first time, besides the failure, where he ever had anything like this happen. In fact, it was the first time he'd ever had anything like this happen. In particular, the failure, the alcohol failure, isn't the same. Okay, but Judge Jones brought him back in, okay, and had a hearing. Now, the other thing that's clear in Florida case law is when you have a revocation like this, see, and this is why they put that second part in, because technically speaking, what should have happened is Ty, let's say if Ty had attorneys, what would have happened in this case is they would have immediately filed a motion to challenge the revocation, to which they would have asked for a hearing to be set, and they would have filed a motion to have him be in a position to come to the hearing, have a contested hearing, call witnesses that would have been people from that site. It would have been his pretrial officer. They would have had the right to confront these people because technically speaking, you don't have a right to revoke. The judge doesn't have a right to revoke bond until they have that hearing and until Ty Tucker has a right to confront this situation. So he wasn't really in danger of going to jail yet. The warrant had been issued. If he tried to flee the country or, he tried to go to the airport. But the reason why they ended up locking him up and he's in custody now isn't because of the urinalysis. It's because he went to the airport and essentially absconded and was going to the airport. And that's why they have portrayed this as destination unknown. That is to justify holding him right now. Because technically speaking, there had not been a hearing yet. And under Florida law, case law is clear on this. In fact, they have reversed revocations in the past. And I don't have my notes with me right now. It's in my iPad over here. But I have cases that I looked up and that deal with this issue and are clear on this issue, that he is entitled to have a hearing to confront these charges or these allegations. So Judge Morgan, again, Ty is a victim of not having legal counsel. Okay, he proved, yes, you can go to trial when the evidence is weak. Okay. When the evidence is weak, well, Sarah, I'll finish my thought here. When the evidence is weak, you go to trial, right? And you get a mistrial. But when you need the attorney most is working through these pretrial places, working through something like a bond revocation, understanding what you can and you can't do, understanding what your rights are and aren't. When you get notified and you're sitting there and you're a layperson and you find out a warrant's been issued and you find out that you're being violated and you don't have a clue what to do. So what do? You do what you think you should do, but the law doesn't necessarily say that's what you should do because there's things you've got to do first, like file a motion to challenge it, request a hearing, get a hearing date, get in contact with pretrial services and let them know, hey, I'm kind of going to come to town for this hearing, file a motion to get to be able to turn yourself in during that court hearing. So if that hearing goes off and Judge Morgan says, I'm finding that this is a founded violation, I'm finding that evidence exists that this was a violation, then they take Tucker into custody. Then the bond goes up to $3.1 million. But he would have never been picked up if he would have followed it. He would have been allowed to come down to Key West. He wouldn't have been picked up right away. But again, he had to have all of that in place. And unfortunately, he can. Well, Flash Fan 85, he did have standby counsel in that case, but not in the courtroom. They would not allow them to be in the courtroom. He had them. It was Jerry, and they were at his office, and he would go meet them, or he could call them to consult with them. but he wanted a hybrid defense, which was he wanted to have the counsel at the table. Essentially, what he wanted to do is this: he wanted to have counsel in the courtroom, and he wanted to be recognized as not just a defendant but a lawyer. And then he wanted to be able to have his counsel be there. So essentially, like before the jury, he could sit there and argue his case and do his opening statements and his closing arguments, but he'd also have counsel there that if they wanted to cross-examine a witness, they could have done it. And there's case law that says this is allowed, but Judge Jones said, no, that's not happening. Either you're going to have them as counsel of record and they're going to be trying this case, or they're going to be out of the courtroom and you can call them. He still wanted to have a defense team in the courtroom. What he was asking for, basically what Ty Tucker wanted, or what he was trying to get at, is he was going to hire in, or he was going to have counsel there where he was going to have a lawyer sitting at the defense table with him. He was going to still be trying the case. He was going to do a line share of the work. He was going to be able to cross-examine witnesses, give the closing statement, the opening argument, but he was also going to have counsel there who would be actively telling him what's going on, who would be actively able to argue a motion outside the presence of the jury, who would be telling him, object to this, object to that, ask questions this way. And the Judge Jones said, absolutely, you're not having that. No way. You're either going to be a defendant with a lawyer who's speaking for you, or you're going to have no lawyers in the courtroom at all, and you're going to be doing everything, and you can consult with them during breaks and when court isn't in session, and maybe you can call them. No, that wouldn't be a Brady violation, because a Brady violation deals with exculpatory evidence, and that's more that Brady relates to evidentiary related things. But no, it would not be a Brady violation. And now what it might be is his violation of a Sixth Amendment right, but to competent counsel. But reality is he the judge doesn't have to allow that. No, so it's not a guarantee. That is something that the judge can grant or maybe not grant. With that. So. All right, so let me get back to this here, because we want to understand this as we go forward and listen here. So the effect of a mistrial, a person who's to be tried again, whose trial has been delayed by an appeal by the state or the defendant, shall be brought to trial within 90 days from the date of declaration of a mistrial, the date of an order by the trial court granting a new trial, the date of an order by the trial court granting a motion in arrest of judgment, or the date of receipt by the trial court of a mandate, order, or notice of whatever form from a reviewing court that makes possible a new trial for the defendant, whichever is last in time. Now, that's what you just heard Judge Morgan referring to, whichever is last in time. But the problem is none of those other things happened in this case. The only thing that happened in this case was declaration of mistrial. So that's when he realizes his mistake and says, well, it is an April date, which was going to put a lot of pressure on them. And again, why Ty Tucker should have absolutely had them scrambling to try to figure out a court date and figure out all these issues, and he should have not made it comfortable. If a defendant is not brought to trial within the prescribed time periods, the defendant shall be entitled to the appropriate remedy as set forth in subdivision P. Now, N says, discharge from a crime under this rule shall operate the bar prosecution of the crime charged in all other crimes on which trial is not commenced, nor conviction obtained, nor adjudication withheld, and that were or might have been charged as a result of the same conduct or criminal episode as a lesser degree or lesser included offense. Null pros effect. The intent and effect of this rule should not be avoided by the state by entering a null pros to a crime charge. In other words, they can't just dismiss the case and refile it. Okay. So essentially, again, if this rule is invoked and they don't try him, he is free. He's free as if he was found not guilty. He's free. Now, the remedies of this is Section P. Absolutely, they would have been a lot different, Flash Fan 85, because first of all, he should have not only not waived speedy trial, but he should have challenged which was his right. He should have challenged Judge Morgan's ability to be the judge, which would have forced Judge Morgan to figure this thing out and forced him to decide to recuse. And then they would have had to bring another judge in. And on top of that, the state would have had to have been ready to go to trial in that period of time. And the judge that would have been brought in would have had to have a clear calendar. If that couldn't have happened, and they would have got to the 29th of April, he, as you're going to see here, there's a procedure that gets followed that he would have been able to potentially walk free. So here's what happens, right? No remedy shall be granted to any defendant under this rule until the court has made the required inquiry under subdivision J. Okay. So the required inquiry under subdivision J is this: if the trial of the accused does not commence within the periods of time established by this rule, a pending motion for discharge shall be granted by the court unless it is shown that, one, a time extension has been ordered under subdivision 1, and that extension has not expired. So let's look at subdivision 1 here. And that would be this: no later than 5 days from the filing of a demand for a speedy trial, the court shall hold a calendar call with notice to all parties for the express purpose of announcing in open court receipt of the demand and the setting of case for trial. Okay. So that had to occur, right? That the judge calls, and that's what he was doing on the 11th. Okay. So that was covering that, and of course, Ty immediately stupidly waives it, but that's what he was doing. The failure to hold trial is attributable to the accused, a co-defendant in the same trial, or their counsel. That was not the case here. The defendant wasn't asking for a delay here. The accused was unavailable. No, he's available. The demand was referred to. The demand referred to in subdivision G is invalid. So subdivision G, let's see here, G. And in that case, we're dealing with a mistrial here, so that's not that doesn't stand in this. If the court finds the discharge is not appropriate for reasons under subdivision J2, J3, the pending motion for discharge will be denied, provided, however, that trial shall be scheduled to commence within 90 days of it. So essentially, under the effects of J, none of these would have come into effect to have prevented it. There was not a time extension ordered or agreed to. The failure to hold a trial was not attributable to Ty Tucker in this case. The accused was not unavailable for trial. He was ready for trial. And that was all that they needed to find. They had to find that was going on. So we come back down here to P, and it says, once they found that J is fine, which in this case, clearly J would not have applied, at any time after the expiration of the prescribed period of time, the defendant may file a separate pleading entitled Notice of Expiration of Speedy Trial Time and serve a copy on the prosecuting authority. So this is why I said Ty Tucker didn't need to waive at this hearing, because essentially on the 29th of April, if they wouldn't have been able to go to trial on the 30th of April, he would have been able to file a notice of expiration of speedy trial time. It would have got served on the prosecution no later than 5 days from that date. So let's just say, I want you all to think about this. He challenges the judge. They don't have a judge. It's April 30th. He files that motion. Now, they're going to have to assign a judge at that moment, because at that point, a hearing would have to have been held, okay? And the court would have to find, and unless the court finds that one of the reasons set forth in subdivision J, which we have just established, there was no reason in subdivision J that exists at this point. Tucker's there and ready. Tucker isn't asking for a continuance, and there's been no agreement on an extension. In other words, he hasn't agreed to continue this thing. The defendant shall be brought to trial within 10 days. So at that point, they appear. They look at the case. If the defendant isn't brought to trial within 10 days through no fault of the defendant, on motion of the defendant or the court, shall be forever discharged from the crime. So essentially, at that point, it's the 30th of April. By the 4th of May, they would have had to hold a hearing. Judge would have said, okay, we find that J doesn't affect at all. That, that there's no exceptions made in that. Mr. Tucker's entitled to be tried by May 14th. At that particular time, okay, and again, this might be where Judge Morgan would have felt the 14th or 15th of May would have worked. They would have said, okay, by the 14th of May, this trial starts. Now, again, this is why Tucker would have needed to have challenged, which he had a right to do, as a conflict for Judge Morgan, which that is no fault of Tyrone Tucker's. He has every right to challenge that. And him challenging that would not require him to ask for continuance. But if they wouldn't have tried him by May 14th, which right now, he'd be walking away as a free man. He would have never had his bond revoked, and he would potentially be free. So yes, Flash fan for 85, things would have been a lot different potentially. Now, at any point in there, if it became clear and Tucker had his motions ready and he says, you know what, I'm going to file these motions, and it becomes clear that the state is going to go forward, at any particular point in that instance, Tucker could have said, hey, listen, I'll agree to a continuance. That way, we're not rushing this thing. That way, we can get a judge in here who can get up to speed on the case. But imagine, just imagine, right? You got a pro se defendant. You got a judge who isn't up to speed, and he's supposed to take it to trial. Can you imagine what a chaos that would be? That would be, what more perfect of a situation? And the reality of the situation is, and this is the part, this again is the part that Ty, unfortunately, didn't quite understand, the fact that the reality of the situation is no judge is going to dismiss this case, more likely than not. Judge Morgan was never going to dismiss the case. So if you can create that kind of chaos, and even if you had to retry the case again on May 14th, under those circumstances where a judge is fresh in the case, has no knowledge of the case, doesn't understand the case, he's coming in, they're trying the case. In this case, John Johnson isn't even in the state anymore. He's going to Texas because he's got to go take care of his dad. Maybe he never makes it back. Get on top of that, guess what? The state still needs to get the transcripts. Remember, one of their big pieces of evidence is getting the transcripts for Tyrone Tucker's testimony that they want to use, because that's all they got, is that alleged testimony that they want to be able to bring in, and they want to be able to bring in Paul's testimony. If they would have never been able to have that, they would have shown up without transcripts, without things ready. And you know what? That's not Ty Tucker's fault. So would things have been different, Flash fan? Absolutely. But watch how this unfolds. So understanding that entire process and understanding how this works, now let's watch the next most unfortunate minutes of Ty's life as he makes a mistake that if he ends up somehow convicted in this case and in prison, we can literally go back here and you're going to see how Judge Morgan and Mansfield worked him to waive his speedy trial. That's what they came into this hearing to do.
During those dates, I don't want to lock you into something specific here, but very generally speaking, is the state. But
now I want you to listen here.
Unless Mr. Tucker requests a continuance, that's my plan, is to try the case during those dates. I don't want to lock you into something specific here, but very generally speaking, is the state prepared to proceed?
Judge, we are. I would just,
Now, a couple things, Flash fan. I would never do a bench trial in this case ever. Okay. Because I wouldn't trust any judge. Now, unless this was a judge from a different part of the state who has no ties in with the Key West, this is a case that needs that if it's going to be, unless you're going to have some sort of a procedural situation like this, put it to a jury. But I want you to watch, just watch just how he is starting it out here. Judge Morgan is like, unless Mr. Tucker's willing to waive it. And you see Ty over there. He's like the kid in the back. Hand up. Please, Judge, I'll waive it. Because I want to be able to tell you that I've got this motion to dismiss. We've got a bunch of stuff. And Mansfield jumps in here and says, oh, of course we're ready to go. So Tucker thinks that he's screwing Mansfield over, that he's going to, that because, again, they weren't ready to go. They don't even have the transcripts ready. Do you think they would have the transcripts ready in a month? At this point, they were asking for the entire record. So they have Tucker believing that that's why the states say, we want to go. And Tucker, the strategy here was to get Tucker to waive. And he did. Because Tucker thought he was pissing them off when he wasn't. He was walking right into their hands. He was ensuring that he was going to get caught in the noose. And he walks right into him. Just watch how this progresses. It pisses me off when I watch this.
I believe that date's going to be outside the 90-day window because I believe this came back from the jury, I want to say January 25th.
Yep,
So
and it was. You're correct, Flash fan.
Would put us
They bluffed him. And he ain't, and apparently Tuck ain't a good poker player.
Okay, well, I need to do some more work on this issue as well, because if you look at,
and look at Mansfield. You can tell this dude is like barely able to contain himself. He's hoping that Tucker's going to take the hit.
Part of that sentence, which is operative, is whichever is last in time. So it's not necessarily 90 days from the date
Absolutely,
of the
sir.
declaration of a mistrial. It could be from the date of an order by the trial court grant. Oh, wait a second. That's not applicable. That's not applicable. Nope, you're right, Mr. Mansfield. It is within the 90-day period. So we're going to have to identify a new trial date anyway. And
Your Honor, if I may.
Judge, the May dates were.
And here it comes, guys. Here it comes.
He would have to agree to a continuance to release the 90-day limit in order to keep those May dates. I think that's how that would have to work.
I could actually clear this up for you, Your Honor.
And notice right there what he does. Oh, yeah. Mansfield used to be a judge. He knows these loopholes. He knows what he's doing. Again, James Morgan has made it clear when you read that article that I presented way back when we found out the tie was getting violated. Morgan is deep involved with these guys. Morgan is, he is the, he's new to the system, but he is the system. He has no desire to break the system down or expose the system or cause trouble for anybody here. This was a bluff. This was a work. How many times does Mansfield say he would have to ask for a continuance? But I mean, we're ready to go. We want to go right now. We're ready for trial. And Tucker's like, oh, hell no, you're not going to get to trial now. Because you know what, Mansfield? I'm going to file these motions and I'm ready to take you on. And we're going to get this thing dismissed. And I'm going to argue this. Again, the stupid strategy. The strategy here, the thing they want you to do is force them to trial because they weren't going to be ready, because they know they need. See, they don't get the bite back at the apple again if they don't have your testimony ready. If they can't get the transcript of your testimony, they can't do some of the things they did if you don't choose to testify again. if you brought an attorney this time and your attorney didn't let you testify, they don't ever get a chance to work you like they did. And if you force their hand to go to trial in a month and they can't get the transcripts, and they can't get the transcripts of John Travis Johnson because he's over in Texas and he can't come in, and they can't find a judge, and they can't have all these different things that are going on, and they're not going to have their transcripts ready to bring in your testimony when you were testifying about an Ashton question regarding the knife, and then on top of that, you were questioned about the Facebook photos, and none of that comes in if they don't have the transcripts ready and available, and they can't use a court TV recording because that's not an official record. So what do they need you to do? They need you to waive your right to a speedy trial. They need you to go walk in there and do that. On top of that, they want you to also waive your right and let Morgan in on the case and let you think that Morgan is going to help you out. And then guess what? The moment he comes on the case, what does he do? He locks your ass up. This is the most unfortunate thing. And I remember, like I said, Ty, this is why, you only can go so far representing yourself before, because a layperson is not going to understand the strategic things. Again, and the reason why I understand this so well is because these are the things my dad did and my dad was known for. It's called creating an issue. It's called finding an issue, crafting an issue that can get a case dismissed, that can create a challenge in the case. And sometimes you force them to trial in an instance like this when they don't want to try the case. And that forces them to have to come to the table, or maybe it gets the case dismissed. Or in some cases, you create an issue that you can tie the case up for years and years and years. And in this case, they had the opportunity to kind of do two things: challenge the judge, which would have tied this thing up, but at the same point, that can't be held against Ty Tucker, and the 90-day rule is going, so they're going to feel the stress of having to try to get him to trial, find a judge, do all this, and if they can't do that, because Judge Jones recused himself, Judge Jones helped Ty Tucker. If Ty Tucker would have been, and again, I don't know who he was in contact with. I don't know if he was, he says he was still talking to I don't think he was, because I think any lawyer down there who would have been looking at the strategic purposes would have never told him, Ty, waive it. Waive it so that you can file your motion to dismiss, which was going to more likely than not be denied. He files his response to his motion in limine, where he's asking in the eyes of justice, because he thinks, I guess, Judge Moore, but apparently Ty was aware of the article that I saw when I sent it to him. I sent it to Lauren James. Lauren, I was told by both of them that they knew the information that was in there. So if you knew that, what the hell are you? Why would you think he would do any of that stuff? And yeah, you can file that motion, and you can file the motion to dismiss, and he'll deny all of them, and it'll put you back in trial, or he'll do like he did right now. He'll just lock you back up. He'll deny your bond. He'll wait till you make a mistake. He'll wait till you're 5 minutes late for a hearing, and he'll decide, you know what, we're going to go ahead and violate you. Just totally stupid. Anyways, let's continue watching.
If I may, I was going to ask for a continuance anyway. The defense has a few more motions we need to file. There's some things we need
never
to
got filed
before we go to trial. But so I would be asking for a continuance beyond the 90 days anyway.
Okay, Mr. Johnson, do you understand that the rule requires that I set this?
Now, are you kidding me right there when the judge did that? This told me that the judge was in on it, okay? He calls him Mr. Johnson, okay? He calls him Mr. Johnson. This whole thing, in my opinion, was a setup. It was a rub. It was a, hey, Mr. Johnson, you're Mr. Tucker. Morgan is like, he's trying to send off this whole thing like, I'm not very familiar with this case. It's unbelievable. But this judge does not in any way come across to me like he is a favorable person to Ty Tucker. Not in any way. And Ty is eating it up. Now watch how Ty reacts to the Mr. Johnson comment. And again, all this is meant to keep Tucker off balance, to make Tucker think, oh, because I want you to understand what he doesn't say. And I want you to watch this waiver. And this is why I think if he got a lawyer involved, you may still be able to go back and you may still be able to go back and get this undone because he did not fully go through explaining the implications of what this is. And watch how Ty Tucker completely shows that he doesn't fully understand this rule. And this judge should have, if he was going to be honest about this, if he was truly doing this in a fair way, what he should have said is listen, Mr. Tucker, here's the deal. I want you to go and consult with legal counsel. I want you to take a few days. And on the 4th, we will go through and we can do the soliloquy and we can go through all of this and we can waive this. But this judge jumped on it way too fast. He didn't give Ty Tucker the chance to research it because he didn't want it. And Ty fell right into it, hook, line, and sinker. Here we go.
This, or could this case be retried within a 90-day period? Do you first understand that?
Yeah, and it's not Mr. Johnson, just to make sure we're clear.
Oh, I'm sorry.
It's okay.
Sorry. There you go. I told you.
No, we actually have a few things.
Mr. Tucker, understand that the rule requires that this case be tried within 90 days of the date of the mistrial?
Right. Yeah, I understand that. And apparently, was it as long as I'm willing to go, as long as I'm okay with a continuance? My understanding is that we could go beyond the 90 days.
Yes, I know, but
Okay. It's more than that, Ty. He's acting like it's like, well, you're going to force me into a trial. No, they're not going to try the case. They got to be ready to try the case in a month. Dude, get a calendar out. This is why I remember of course, I wasn't watching it live, but I remember reaching out to him and he ignored me. He didn't say anything to me about it this time. And he was, and ignored the issue and just kind of went right over it. And then I saw him, I think he was on another show and I saw him talking about it. And, who is home? What do you mean by that, sir? But I'm sitting here like, what are you doing? Why are you doing this? Why would you do this? Did you not see what's happening right here? Because he didn't even understand this. He thinks that it's like, oh, I want the right to be able to give all. Listen, you could have still filed those motions. Those motions didn't. It just requires that a judge deal with the motion, and requires you be tried within 90 days. He could have still filed those motions. Now, the judge would have had to figure it out, and there would have had to be a judge on the case. But the issue was we didn't have a judge on the case right now. You don't waive it before there's a judge on the case. Before it's possible this case can never make it to trial. You don't have a judge on the case that even knows the case. Judge Jones handed him the ability to get this case All right, I apologize, guys. I don't know what happened here. My home internet cut out. That was very weird. It wasn't the typical issue because normally it doesn't let me back on in the previous ones, but my home internet just literally cut out. Very odd. But anyways, so what I was saying before I got cut off is, and again, I'll look at the comments here because there was a good one here that I saw. On the other streams, he went in and he was like, yes, exactly. He wasn't taking this serious. He was not taking this serious in that sense. You know, he was, oh, you talking about on the home here? Let me see here. You're talking about, I think it says phone actually, not home in the middle. But yeah, he wasn't. And he was just not paying attention. He wasn't understanding fully what was supposed to be happening here. All right, guys. I have no idea. My camera dropped out. We're having all sorts of interesting issues. My camera disconnected, so that's weird. Like I said, we get into this Ty Tucker stuff, and boy, weird things start happening. But essentially, yes, I agree with you, Flash Fan 85. He didn't take these things serious, and he isn't understanding what's happening right now. And they are walking him through. Judge Morgan is walking him right through this. You can tell that he absolutely believes, or doesn't believe, but that he absolutely knows he has Ty Tucker right where he wants him. Ty's waving this thing, and it was the stupidest thing he could have done.
Sometimes I'm going to ask you questions, and I need you just to answer the question that I'm asking you.
Okay.
Go in a way methodically through the rule to make sure that you understand, because obviously you're making a waiver of this right.
Okay, so something important here. First off, let me answer this question from Sarah. Is the 90 days? No, the 90 days is from the declaration of mistrial. Okay. Or had there been an agreement of the continuance where he says, we're agree to a continuance and we'll waive this 90-day rule from whenever that expires. So essentially what he agreed was obviously to this new date of September 2nd. So if for some reason that trial doesn't happen on September 2nd due to something that isn't the fault of Ty Tucker, the 90-day clock would start again. And he would be able to come back and say, I want to assert, I'm going to file a motion, and essentially judge would have to call him up and they'd have to be ready for trial within 10 days. But that's essentially not going to happen because at this point, the judge is going to if something has to be continued, they're going to all be in agreement going forward from this point forward. So this will never be another, issue again that Ty Tucker would be able to utilize the way he could have utilized it here. But what I want you guys to pay attention to here is he says, I'm going to walk you through the rule. Okay. Ty clearly isn't understanding this rule. He's believing that it's just a simple rule. He's not understanding the outcome of this rule could result in his case being dismissed and never being able to be filed again, which is something you would expect the judge when you're waiving something like that. And this is why I say there's potential here that a knowledgeable attorney could come in here and say, well, yeah, he waived it, but he didn't waive it with full understanding. Now, they'd have to find case law on it. They'd have to find, and again, a good attorney is going to be able to do that and probably have cases and no cases right away that they can bring up. But I don't believe the waiver here. I believe there's an issue with the waiver here. Now, whether it'll ever get challenged, whether If Ty represents himself, it'll never get challenged. And I think that's what they're banking on here because, again, the fact that this got waived in the first place was just incredibly stupid. But let's watch.
Okay? You have
Yes,
the,
sir.
of this rule. This rule requires something to happen. I want to make sure you understand the rule. I want to make sure that you don't need any additional time to think about it or to discuss it with anyone or to seek an attorney or to do anything at all. Because that way, into part 3, I can then, assuming that you're good with everything, I can make a pronouncement that you've knowingly and voluntarily waived your right to this rule-based time period that requires the case to be retried. So again, do you understand that under this rule, the case is required to be retried within 90 days?
Yes, sir, I do.
Okay. Do you need any additional time to either think about this or to consult with an attorney? I'm not going to give you a bunch of time because the rule is based on time. I'll give you a short period of time if you wish to consider your options here, unless you're willing to make a decision today.
Yeah, I'll go ahead and make a decision today, Your Honor. I'll go ahead and waive that.
Okay, sir, I'm going to find, sir, are you under the influence of any alcohol, drugs, or medicines at the
I don't think it's any clearer what the judge is trying to do here. He literally just tells Ty, it's like, I'm willing to give you time with an attorney unless you're willing to. And notice how he like enunciated on today, unless you're willing to waive it today. And then it's like, Ty says, no, I'm willing to waive it right now. Why? You don't even understand what the hell you're waiving. But here's the thing. The judge is about to take him through and basically say, are you under the influence of drugs or alcohol? Nope. Now, that would be another thing if Ty could somehow say, hey, I was under the influence of alcohol or drugs or whatever. But what's he going to say? He's going to say no, of course. But if there's a way to go back and prove that he was, that would be another way you could undo this unfortunate travesty. And you could retroactively go back and say, well, he didn't get tried in that period of time and maybe get this thing thrown out. This is a potential possibility. But watch, he doesn't take him through the rule and he doesn't make him understand what he's waiving. No, he didn't. That's what I'm saying. This is so clear that this was a manufactured setup that Ty walked into and got absolutely hammered by the judge and the prosecutor who were teaming up against him. He was getting screwed over, bent over, worse than Judge Jones ever did it. Well, I don't know if that's worse than ever did, but this is egregious. This is some horrible shit because what we know Judge Morgan does next, after he gets Ty to essentially waive the right to challenge Judge Morgan being involved in the case, he gets Ty to essentially waive his speedy trial and set a trial out to September. And now Judge Morgan then, once they have that all set up, boom, signs the revocation. And now Ty's going to sit in jail till September. Or whenever the hell the state wants to try him. And Judge Morgan walked him right into this. Here we go.
No, sir.
Is anyone forcing you, threatening you, coercing you, or
yourself
otherwise making you to waive the rule-based time requirement for this retrial?
No, sir.
All right, so I'm going to find that you knowingly and voluntarily, after considering all the options, made a waiver of this 90-day rule-based requirement for
what you just saw there is the look of victory. Did you see him rubbing his hands together? And he makes that weird, oh my God, he's rubbing his hands together. He's like, we got you, Tuck. We got you right where we want you. You are the dumbest guy in the room. You think you're the smartest guy in the room, and we got you. Couple of attorneys. Absolutely, he was. Judge Jones was a little scared to try all these dirty tactics blatantly. But Morgan doesn't care because Morgan feels like, see, here's the deal. Jones has been framed as the guy who's been in it from the beginning. He's an insider. And I think Judge Jones, to a degree, he knows Tucker's innocent. He knows it. And I think by the end of that trial, he kind of knew it. And I think it was like, if the jury convicted him, okay, the jury convicts him. 12 people convict him. It's out of his hands. But I think by the end of that trial and seeing everything and seeing the case that they ultimately did and seeing the lengths that had to happen in order for them to try to get this guilty verdict and then it wasn't successful, I think he was just flat out uncomfortable. But I think he was also scared to death that now he has a whole army of internet people willing to look into this case and see the different things that he did and seeing the different things that were going on in the case. And I think he was scared to death to push forward. But you're correct. I don't think Judge Morgan gives a shit because he knows, again, the magic of Judge Morgan is he's a new judge who can't possibly be part of the Bubba system because he wasn't even there. He was at the public defender's office. He was with the people that were defending. He was defending Johnson. His office was defending Johnson and Wilson. He was on the defense side, not on Bubba's side. He was a military guy. He's from out of the area. He came in. But listen, the bottom line is he's as Bubba as he can. He's in with a big hotel group down there. He was like their director of operations and head of all that before he became the judge. He's big money. He is as deep as you can be. And then Judge Jones goes and recommends him and for the judgeship and swears him in. And both of these guys have a love fest in that article going back and forth. Are you kidding me? And now he walks in and he's like, we got this guy. And he believes he's got him. He's like, and I believe he's got him. I think Tucker is in real danger with how this retrial is going to happen because it ain't going to be conducted like it was in January. He's going to have a real problem, an actual real problem. And it's scary. And this judge might be dirtier and more dangerous than Judge Jones because this guy just doesn't give a shit. This guy's just willing to do whatever it is. How you doing, Megan? Thank you for stopping in. This guy is just willing to do whatever, he's willing to, well, obviously we've seen the lengths he's willing to go. So when we're watching this is before we knew what he was willing to do. And we know the playbook that came in. He waives the speedy trial. He gets him to keep him on the case. He gets him to not challenge him being on the case. And then he goes and revokes his bond. And here we are. Anyways, let's continue watching.
Retrial. And so, now going forward, what I would like for you all to do is, we're not going to set anything today, but Mr. Mansfield and Mr. Tucker, I want you to write this down because Mr. Tucker, the first thing you should write on your page is, this case will be retried in 2024. Okay?
Yes, sir.
This case will be retried in 2024. And I'm going to give you 3 options for dates right now. I want you to at least consider these options. I do not want an answer today, but I would like you to at least consider your availability for trial during the following 3 dates. I do not have dates for the second half of 2024, but I will have those dates soon. The dates I would like you to write down for consideration are as follows: May 13th through the 24th. June 3rd through June 14th. Actually, I only have 2, I'm sorry. I can only do these 2 dates.
I agree with you, Flash fan. Absolutely. I agree with you 100%. He's got to pay back, Joe. He's got to pay the system back.
Question I do have is
now watch this.
The original trial was scheduled to last a month, not 10 days. So don't get me wrong. I fully plan on bringing my witnesses and having all my witnesses available to me this time, as they weren't in the first trial. So. And that trial took, 10 days without my witnesses being called. So I'm wondering if it's going to be enough time. That's the question.
Well, sir, I'm glad you brought that up. It may not be, and so we may have to look at dates in the second half of the year. So you bring up a valid point. However, I know you're unfamiliar with me, and although this docket today is a very poor example of efficiency, however, what's going to happen during your trial week is this case will be tried efficiently, which is probably not something that happened during the first trial period. Now, for various reasons during an initial trial, and frankly, in abundance of caution, um, judges like to make sure they're doing the right thing. But this case has been tried once, and I don't anticipate some of the same hiccups that we may have going forward with this trial. Now, that being said, you're right, we may need more than 2 weeks. It may be wise to set aside 3 weeks. So as I look at my calendar in the second half of the year, you're right, I'll probably take a look at 3-week periods to retry this. But my point is, at least for our next conversation, I'd like for you to all at least meaningfully consider those 2 separate 2-week trial periods. Now, I mentioned the case would be retried in Key West. Again, that is my tentative plan, and that is going to be based on me coordinating with our circuit court administrator. Now,
All right. So that's all we need to hear of that hearing. He goes into talking about some scheduling things, et cetera, et cetera. But the point is, he walks Ty Tucker in, he waves it. You heard. You also, the reason why I played that last part is because I wanted to highlight the fact that Ty comes in and says, it took 10 days last time. We're going to need more time. And pretty much this guy tells him straight up, dude, that ain't happening. And he says there were some issues in the last case, but we're not going to have those same issues. What were those issues? Well, we know what those issues were. Ty was given a lot of leeway. He was given a lot of leash. He was allowed to, he hung up. He was given a wide range on cross-examination. And he's basically going to come in and he's going to shut Tucker down. He's going to basically make it clear, if you don't know how to question a witness, that's on you. You should have brought an attorney in. You had every right to bring an attorney in. You're not going to waste this court's time because you don't know how to ask questions. You're not going to come into this case and you're not going to make this thing last 6 weeks and waste this jury's time. You're going to ask the questions or you're not going to ask. If you can't ask them properly, you're going to be told to sit down, shut up, and go on. You're not going to get a chance to bring these reports in front of the jury. You're not going to get a chance to do the things that he did. Now, I want to also bring in here, because I had, we're going to go back to share the screen here. Hopefully you guys can see this. Let me see if I can. I don't think I can blow that up anymore. But in the event that you can't see it, hopefully you can. It says, this individual, Chad House 2059, says, I think Tucker made a horrible mistake asking for a continuance. The state has to retry this case within 90 days. Sometimes the state and the courts cannot do that simply because of court files, time restraints, and so forth. I feel like he would have possibly gotten off simply because they couldn't proceed within that 90-day mark. The state was probably extremely happy hearing him ask for continuance. Ha, ha, ha. He waived his rights now. So Tuck actually comes in and replies to this, okay? And I put a like on this. This is what Tucker says. I put a like on this because I thought about that too. And I could have pushed that just to see what they would have done before waiving the right. However, I would have also been gambling because in order to comply, the judge could set a date much earlier than we're ready to go and knocked out the chance for dismissal without trial. Judgment call. And again, not a judgment call, just bad strategy. Just bad strategy, flat out. Bad strategy. Terrible strategy. And this is exactly why you don't go and enter a case without an attorney. Because Tucker he called it a judgment call. It was just flat out stupid, bad strategy. Okay? That's what this was. Because the reality of the situation is Ty doesn't want, and the other issue is Ty has a problem, and I've sensed this around him at times. He has a problem admitting admitting that he's wrong, because I guarantee you he might have considered it a little bit, but he didn't, because in his mind, all he's worried about is getting this dismissal, because he wanted. And again, this is the problem that he can't seem to understand. I mean, look. Let's go look at the case right now. The case that Jose Baez is arguing, the Microsoft lady, the Bradigan, I think is the name of the victim. I can't remember her name off the top of my head, but they filed for they filed for a dismissal because there was prosecutorial misconduct in that. They violated the attorney-client privilege in that case. Due process, they went in and looked at protected statements, looked at protected messages that were had between her and her attorneys, and they didn't follow proper protocols. And the judge ruled against Shanna Gardner. That's exactly what the case is. They ruled against her in that case. I was in there digging into her case files just because it's a case that I'm looking at, and they just had a hearing on it, and I like Jose Baez. But they ended up, even with Jose Baez, a very competent, a very good attorney, filing motions, the judge in that case figured out a reason to deny the motion. It's going to go to a jury. Okay? It's going to go to a jury. So this idea, Tucker was obsessed and has been obsessed with the idea that he was going to that he wanted this case, he was going to force a judge to dismiss the case. No. And if the judge is in on the fix, you're never going to get it. The remedy to fix misconduct, when it becomes from the bench and it comes from the state, the remedy that's fixed into our system is the jury. And they can still affect things, but the jury is who you've got to go to. You've got to take that case and you've got to figure out how to put a case to the jury. And then if the jury doesn't do it, it's the appeals court. And yes, that's a tough pill to swallow, and you're the one doing the time waiting on the appeal. But that's the options. Oh, absolutely. Flash Fan 85. Jose Baez would have tore this case up. Ty Tucker would be home right now. And I've heard people be critical of Jose, but let me tell you something. Jose Baez is a great attorney, and if you want to have any proof of it, look at what he did for Aaron Hernandez. He went up there and beat the Aaron Hernandez's second case, the case where he was accused of shooting two guys outside a nightclub, a case that was stronger than the first case, and he beat that case. And he was working on an appeal for Aaron Hernandez when Aaron Hernandez took his own life in his prison cell. But the bottom line is, yeah, somebody like Jose Baez would destroy. That's why I question the idea here. The attorneys that were involved, while they know the case and would probably be adequate to go in and try this case now if they were the only ones left, but I don't believe necessarily that they were the best attorneys that money could buy. They definitely got they got money that was well above probably what they were worth. But looking at their motions, looking at the things that were put forth, looking at the motion to dismiss, again, looking at it from an eye of having been around, in my opinion, the best attorney you've probably never heard of or watched, my dad. And he was the best attorney in West Virginia. And I think he was bar none the best attorney against any attorney you'd see out there in the country, including Jose Baez. And I've read his motions. I've been around him. I've discussed things. These were not top quality motions. That there wasn't defined case law. There wasn't cases that were brought in. The issues were not. There were other issues that could have been brought up. There was never an issue made. Listen, where in this case, and again, I've been through Tuck's case file. There was never a motion made to disqualify the Monroe County State Attorney's Office. Where was that motion at? They were asking simply Colleen Dunn get out of the case, but they're claiming Dennis Ward isn't removing her right away. Why wasn't her attorneys, or why wasn't his attorneys, why did they never file a motion to disqualify Dennis Ward from the case? You have a state attorney who's violating the due process rights, who's hiding evidence. The remedy in this case, the only way you get this case taken care of is get a fresh set of eyes to come in and review the case. So why are they still allowed to be in this case? Jose Baez filed that motion in the Shauna Gardner case, and that was over the fact that we had attorney-client privilege violated, and effectively her due process rights were violated because now that state attorney's office couldn't do it. But you have a state attorney's office who's manufacturing evidence, who's putting people who you're saying who you've got a state attorney's office who's gone in and destroyed files, who you've got all of these things, and you haven't asked that they be tossed from the case. That was never asked in this case. Why? I'll tell you why. Because those two defense attorneys were from Key West, and they were feeding Lauren Janae this line of bull hockey that you can't bring in outsiders down there. That's bullshit. That's like, I mean, they used to say that about down there. My dad came in. He was an outsider in the community that we lived in. And he'd come in. That's bullshit. If you know the law, you come in, you can file the motions. You're going to muscle your way into it. You're going to create the issues. You're going to bring case law in. That's what, if you go back and read the motion to dismiss, even the gag order that gets entered, it's like, where's the challenge on this stuff? Because but the bottom line was, what it was is they were afraid to fight because they didn't want to go piss off the powers that be, because they were believing these powers that be were just too impossible to go. They wanted the money. They wanted the big payout. They want to take advantage of the millionaire woman that's here to help Ty Tucker, but they weren't necessarily the best attorneys that money could buy, not even close. And that's why, the unfortunate thing for Ty is, he's obsessed with, well, exactly. And Karen, that's exactly right, Flash fan. Yes, Alan Jackson is an out-of-state attorney, and that's exactly a great example. I'm sure down there they would say they don't like outsiders coming in. But guess what? Karen Reed case, it's happening, and he's defending the hell out of her. They're doing a hell of a job. So this whole idea that you can't have outside counsel in Ty Tucker's case was ridiculous. You just didn't have the right counsel, and Ty's realizing that, and it's people are doing the best they can. Not everybody has the ability. I have had the unique experience because I literally was raised by and around one of the best legal minds that you will ever find. And if you don't believe me, I can introduce you to 100 people that will back up what I'm saying about my dad. So I had the unique experience of being around an individual like that, of understanding that, yes, there are things that can be done that you might not even think of, that there is ability to look up cases and find case law and challenge things and do things that go beyond what you think is possible. And that's exactly right. Yes. Megan Bassenbacher, that is exactly correct. Yes. That is exactly how he's approaching it. And look, I have also been around the other side too. My dad's been around it because remember, oh no, you're fine. He consulted with different attorneys. There were times that my dad would, during the back half of his career when he wasn't actively practicing anymore and he was consulting. And there were some cases. There was one particular case that involved a guy who got beaten by the local police. And they had to go in and challenge it. And there were some dirty, dirty things. I'm not going to get into all the facts and details of the case. But there were some dirty things going on. I remember there was a motion that had to be filed. They were fighting. They were going in. And the particular attorney that was involved refused to go and do some of the things because they were afraid. And my dad explained to this attorney, and ultimately it was the attorney's case to win or lose. They took a plea. The attorney took a plea. My dad said you should have never done that. He didn't need to take a plea, but they backed off. They took the plea. And remember, Ty's attorneys came in and wanted him to take a plea. That was one of the splitting things. They wanted him to take that plea. So the idea here that he had attorneys that were ready to fight for his innocence, they were ready to go so far, but they were not willing to shake it up themselves either. They were not willing to go and make things uncomfortable for themselves into the future. I mean, they did a little bit, but there was a limit. There was a limit. But the other issue, like I said, as you see in here, is Ty has, the problem that some people get into, and some people have, and especially if you're going to have the balls to take a case to trial. He thinks he's really smarter than the lawyers. He thinks he's smarter than everybody in the room. And unfortunately, he isn't. He just isn't. And it's not saying he's not smart. He's obviously a smart guy because he was able to defend himself, but he's not aware. He doesn't understand the law. He didn't understand what he was waiving. And because he did, and he has an inability, as a lot of people do, to say, I don't know. I didn't understand. I need to know. Because he got caught up, I think, that, the worst thing, and again, I guess I'm part of it because I was covering his case, but he never came on my show, and that was part of the reason why I was like, I wanted to interview Ty when he was found not guilty. I didn't want it going on now because I didn't feel comfortable. I don't ever feel comfortable when any defendant comes out and speaks. Because remember, every time they speak, whether you're innocent or guilty, every time you speak, it can be held against you. So the last thing I really wanted from Ty was come on and talk about this case on a public forum. Because it can be used against you. It's recorded. And, I know he's innocent, but the bottom line is I think he got caught up in that persona where he felt like he was coming out here and he was going on the shows and he was acting like, I know the law better than the lawyers and I know the law better than the law people do. But the reality was you don't, because you don't understand the ins and outs of it. You don't understand the strategy. You don't understand how to use it in a way that can benefit you and maybe even get your case dismissed. And he's talking about in here that's what the crazy part is. That's one of the reasons why I highlighted this. However, I would have also been gambling because in order to comply, the judge could set a date much earlier than we're ready to go and knocked out the chance for dismissal without trial. What the hell are you talking about? The whole thing was you would have got your dismissal without trial if they didn't get you to trial, and you could have still continued it. What the hell? And Flashfan says he doesn't like to admit that he's wrong. no offense to him. I believe 100% is, but I think he does not like to admit. No, he does not. And I've been told that even by his wife that he struggled with that. And he doesn't fully understand the nuances of the law. And that's why he had conflicts with the attorneys. And he was just very difficult to deal with. And even myself, when I would try to, suggest things or just say, I could just tell. But again, I'm not a lawyer, so I was not trying to give, I can't give him legal advice. I can just point him in the right direction or say, consider this. And that's all I ever did with Ty. Because that's not what I would never want anyone to ever rely on something I said because I'm not a lawyer. I just go on and, hey, I found this case, read it. Tell me what you think. This is what I think it means to me. Do with it what you want. I can't tell you how to apply it. I can't tell you how to use it. I can just tell you this exists. There's a line. But yeah, I don't think when he was on with lawyers who were telling him, like when he was on civil law, it was like he didn't understand or he didn't want to just say, hey, yeah, I don't know this, or yeah, you're right, or maybe I could have done this. He would always have an excuse. And he would say, well, I couldn't do this because of this. And it's like, no, Ty, that's not really true. You could have done that. You should have done that. This could have happened. Megan says, I agree. I choked when he waived it. He had everything ready. It would have just be going back to, yeah, absolutely. And the thing was, here's the thing. He never even filed the motion. He never even filed the motion to dismiss that he waived it for. He just thought when he was in that moment, they played him. And what he really thought he was doing is he thought that okay, here's what he thought. And here's what I know this because I listened to him. And then later on, I asked him about it and we were talking about it. And he was saying, yeah, he really believed that they were afraid that they were afraid of his motion to dismiss. That's what he thought. He thought they were so afraid of his motion to dismiss in the misconduct in the first trial, he thought that they were trying to rush to trial to avoid his ability to argue that motion to dismiss. And the reality was that was not the case at all. What they really want, they don't care about the motion to dismiss. That shit's going to get denied one way or another. Okay, and he's going to have to go in and argue it. He's not going to understand all the different factors. They're going to run circles around him when it happens if he doesn't have an attorney in the courtroom. They ran circles around his attorneys. But he certainly isn't going to be, he's going to be say, hey, this and that, and they're going to tell him that's not quite what it means. That's not quite how it works, et cetera, et cetera. He's going to make the argument. They're going to deny him, and they're going to move on, and they're going to try him. But the reality was they weren't ready yet for trial. And their goal was to delay this. But they didn't want to look like they were delaying it. Will the bond money be lost by time? Well, here's the thing, Sarah. He didn't actually put up the bond money. What happened was Lauren Janae paid a bondsman a fee. The way it works is, so the last time that bond was set, she paid $2 million. She put her house up, right? So for that, she put the house up. Which, no, even if she would have done that, the money comes back because Ty ultimately is in jail. So the money isn't lost or forfeited. He wasn't fleeing. He ultimately comes back. But so as long as he shows up or she goes and gets him and brings him and he ends up appearing, she's fine. But right before that trial occurred in January, Judge Jones actually modified everything and took Lauren Janae off of the bond. She paid a bond. She paid a surety bond, which was like $10,000 on his behalf, to a bondsman who was holding the $100,000 that the bond actually was at. So that money was lost the day she paid it because nobody had to come up with $100,000. Oh no, absolutely. And then Megan, you said you can argue that when the state rests. Argue what when the state rests? Are we talking about? You're talking about arguing like his defense? I mean, in Flash Fan, I agree with you. They're not scared of his. They're not scared of the motion to dismiss. I mean, they're not scared of any of that. And well, Megan Besser, what you're talking about is a judgment of acquittal. What I'm talking about is Ty wanted to file a motion to dismiss, which would have been on different grounds than that. The judgment of acquittal, which is basically saying basically, it's what you call, basically the state has to basically saying the state didn't meet their prima facie case. In other words, that they can't prove the charges. And again, it's a little different than what happens when you're arguing a motion to dismiss prior to trial, because the motion of acquittal, judgment of acquittal, basically says that all the evidence presented by the state without a defense being put on, judged in the view most favorable to the state. In other words, the presumption of innocence isn't applied. It's actually, in this case, oddly enough, the presumption goes to the state that they've met their burden in every favor, everything is broke towards the state, which is why it's so difficult and why those are routinely just denied by judges. I mean, unless the case is just so weak. Now, originally, Ty believed that if Travis Johnson did testify, that he would have that they would have been forced to file or forced to find a judgment of acquittal, or forced to grant the judgment of acquittal, because they wouldn't have made a prima facie case. They would not have been able to make even a base level case to say, even viewed in the most favorable light to the state, there was no evidence of his guilt. However, the motion to dismiss that he wanted to file is totally different, because this is viewed basically from the standard of you're looking at a lot of other factors. Like they were looking at essentially the basis for the Ty wanted to file that motion, and maybe he may still file it, but the basis for his motion is based in the fact that his due process rights were violated. In other words, his 14th Amendment right to due process, his right to confront witnesses, his right. And basically the Supreme Court has held that it is impossible to confront a lie. It is impossible to confront manufactured evidence, and it's impossible to confront a witness that the state puts up and knowingly knows is perjuring himself. In other words, you cannot defend yourself against a lie. So as a result, if the prosecution and the judge knowingly put forth false testimony to a jury or a grand jury, either one, then the Supreme Court, United States Supreme Court, has held, and state courts have held as well across the nation, that the remedy for something like that is dismissal, and not just dismissal of the case, and you can refile it, but dismissal of the case without prejudice. There were cases Ty had that he had come across. I'll leave it at that. But there were cases, and he, again, motions like that very seldomly at the trial court level get granted. But you got to file them, and you got to create the record, because once the trial happens, it all becomes part of the appeal. You can then appeal the motion to dismiss to the higher court as part of your appeal review of the entire trial record, stating, in fact, and then especially if at the trial that you're, again, in this case, John Travis Johnson testifies again. And in this case, it was the idea that John Travis Johnson is fed the story of Ty Tucker being the getaway driver. And then after that, appears in court, testifies, but the state knows that he had filed a motion to suppress. The judge knew he'd filed a motion to suppress as he was the judge on the case. And in that motion to suppress, he alleges that he was fed the story from Penny Phelps, and he alleges that he's lying and that the story that he told Penny Phelps isn't true. Then he takes a deal and he goes back on it. The problem is that while, yes, in theory that meets the standard, but it doesn't necessarily mean that the state has to accept, if you have a witness where he says, well, I did that, well, I went on both sides. He might not be credible, but that's an issue for the jury to consider. Now, the fact that the judge prevented that motion from going before the jury is an appealable issue, and it's an issue that might get you a new trial. But the problem is, Ty felt like, and still feels like, I'm sure right now, I've got this motion, and when I put it forth, I've got proof that they knowingly put perjured testimony. Well, not necessarily, because he could have been lying and saying, yeah, in theory, and this is the way a judge would look at it, he could have been saying, yeah, through his attorney, yeah, I didn't say that. And the attorney at the time had good faith to believe and rely upon the fact that his client's telling him, I never actually did this. I just said that because she told me to. So he goes and files that motion, and then later on it comes back and his client says, you know what? I was lying. Now, he never testified to it. He never swore in an affidavit. So technically his client's not going to get charged with anything. But the jury now can consider that in considering the credibility of John Travis Johnson. But it's not a guarantee that just because you have that the case gets dismissed on due process grounds, because that's not a clear situation. Now, the fact that they withheld Todd O'Quinn's testimony from the grand jury, that's a clear-cut due process issue, but the judge found that in his opinion, it wasn't completely clear the circumstances surrounding that. And was it just that they didn't ask about it, or they chose not to present it? This is how you knew initially the state was scared to try Ty, was that they offered him a time-served plea. I feel that at this point he should have just taken. Well, you know, the issue at hand with that, Flash fan, is, and again, that's why in the last live I told Ty, I said, if you were to take that plea now, because it's still on the table, just so you all know, it's still on the table. He can still take the plea. Part of why they're locking him up, I believe, now was to put pressure on him to take that plea. They want him to take that plea because they know it's not guaranteed. Even if Judge Morgan comes in, listen, at the end of the day, okay, the beautiful part about this case is at the end of the day, Judge Morgan can try every dirty thing he wants. But at the end of the day, if Ty Tucker stands before that jury and says, and he's able to go to the law library, and he knows now how to get that testimony in, and he gets a good subpoena, and he brings in Seth LeVay, and he gets the custodian of records in to get the IA report in and be able to recross examine Malone on it, and he's able to get the custodian of records to bring in, because he doesn't actually technically need Seth LeVay to come in for that. He just needs to call the clerk of court where it was filed, and they can bring it in and put it before the jury, because it's not going before the jury necessarily as fact. It's going for impeachment purposes to be able to question John Travis Johnson on it. And all he needs is just to be able to show that it's a valid business document used in the course of business, filed with the court. And then he can say, this was filed. Did you or did you not have your attorney file this? You were aware it was filed. And then the jury can consider the fact that he had his attorney file something that says the testimony he gave them is false. And then that's it. And then he goes in again. A good attorney understands, and this is why the judge even tried to counsel him. It's about what you argue to the jury. And this is where Ty has to button it up and tighten it up. He's got to understand that you got to be willing, you got to be able to take that and argue it in closing arguments and say, this guy, you know, based on the law, his testimony is evidence, right? It's the only evidence against me. But if you just learned today that prior to Penny Phelps walking in and telling him who the asshole of the story was, it doesn't look like, to me, when you watch that tape, like John Travis Johnson thought Tucker was involved at all. Suddenly he's being told the asshole is Ty, and you need to implicate Ty, and you're now the getaway driver. And he's thinking to himself, holy shit, this is my way out. And he does exactly that. He says he's the getaway driver and Ty is the guy. And just like Ty made the point, you don't need any special knowledge. The allegations aren't that Penny Phelps fed him, who did what in there, or how they walked in or what they did. He was the guy doing it all with Rory Wilson. So all he's got to do is just say, that's what Ty did. And I sat in the car. He knows what was happening when he's running out. He knows what was falling out of the bag. He can do all of those things, and it's not a problem at all. And it's not a problem at all. And that's, so, he doesn't need any special stuff. But he's got to be able to stand up there and say, listen, this is it. This is what you have. And like my dad, I remember passing this on the Ty, and I said, there's an actual, West Virginia gets there's a jury instruction that you can give. And it basically ties very nicely in with the argument, which my dad's always said, you always make this argument whenever you have an individual like John Travis Johnson, who's, you're relying solely on his testimony to convict Ty Tucker. And you ask the jury, listen, if you, what they're asking you to do is make a life or death decision, right? And again, this is what would have really been a very nice personal touch. Ty Tucker stands up in front of that jury and says, they're asking you to make a life or death decision about me. So I would ask you this, before you would even consider convicting me on this man's word, I want you to consider this. If John Travis Johnson's word, if he came to you and you're a close family member, your daughter, your son, your brother, your mother, and you only had John Travis Johnson's word to rely on, and you had to make a life or death decision, do you trust that man enough to, with only his word, would you act on it? Would you make a decision that could cost cost the life of someone close to you? And if you wouldn't, if the answer is no, that's reasonable doubt, and you need to acquit me. And the best part about it is I can tell you not guilty. As I can tell you I'm innocent. But if that's all we got, and you got a guy here who was fed a story by a detective, has his attorney file paperwork that says that story was fake, only when he's offered a plea that gets him immediately released does he come back and say, oh, now it's true. And this is what the state's coming in. The DNA is inconclusive. Roger Ruggett says there's a guy similar to my height. Well, guess what? John Travis Johnson's similar to my height. He's small, a little bit smaller than me, but he's similar in height-wise. But Roger Ruggett says, I don't know who it was. Paula Belmont says it wasn't me. And there's zero evidence that I was anywhere near this. The only two people that we know for a fact that were there are John Travis Johnson and Roy Wilson. And that is the only people. We know John Travis Johnson's there because his truck's on film. Roy Wilson we know is there because his DNA is there, because we see him on film. And the only two people we see walking on the Keys Electric are those two guys. And on top of that, where's the film of me walking back to the warehouse? Where's the film of the truck? Where's the film here? Where are these missing things? All of this is reasonable doubt. That's it. Morgan, all these guys can do whatever the hell they want. All Ty's got to do is be able to stand up before them and close strong and tell them, I'm here to tell you what to think. Not do like he did last time where he says, I can't tell you what to think. And if you think that the evidence, what the hell? What? You can't do that. What? And again, we're going to watch the closing arguments. We're gonna do that in another video, because that's the point where you start. And we're going to debunk the state's closing arguments once and for all with all known evidence and the bullshit they pull there. And then we're going to talk about ties. And we're going to talk about, that's why we end at that. Thank you, Defense Rest. I appreciate it. Yes, support the channel. Go to the coffee.com site, because that is where, like, I did post up information earlier in the week when I was on the road and whatnot. I posted up information when Ty got booked into MCO detention center. That's where I will break things and put things up. So definitely get over there, follow it. You can become a member, but you don't even have to do any of the payment stuff. But it's a spot you're getting notified via email when I post something, when I go live, etc. Keep you up with everything. And then, of course, as I mentioned, the new channel, I'll be posting stuff over there as well for that. What cases we're following on all of that, and schedules and stuff. Sarah says the DNA was inconclusive. That's correct. The DNA was inconclusive, meaning there were spots on there that they don't know whose it was. But guess what? Inconclusive in a criminal case in the United States of America, you know what? Because you presume the defendant innocent, that's evidence that he's not guilty. That should be presumed, that if it's inconclusive, we presume it's not ties. Flash Fan says, I would have taken a step further and said, what would you do if you were serving a life sentence and they said you could get out if you testify against someone? Why should you take his word? Right? Exactly right. That's exactly right. I mean, but again, when you go back and watch that closing argument, you understand why there was a mistrial, why Ty didn't get not guilties, because he didn't do what he needed to do in front of that jury. Because as much as he was as confident, as much as he likes to be able to make an excuse why, well, I'm not wrong here, I'm not wrong here, I'm not this, I'm not that. The bottom line is, he doesn't have the confidence to stand up there himself and just say, I'm innocent. And that's a problem. It doesn't mean he's guilty at all. It just means that it was like he was trying to evoke sympathy. Like, if you're going to he was trying to like do reverse psychology on him. Like, this case is so ridiculous. Like, if you're gonna, but the problem is Ty, you're so involved. It's not completely ridiculous because unfortunately, a lot of jurors do the one thing they're not supposed to. They assume because you're there and the full apparatus of the state is coming down on that individual and is prosecuting you, they assume there's a reason for it. And that's a problem. So you've got to stand up there. Your job was to stand up there and tell them what to think. Absolutely 110%. So with all of that said, having gone through the video, of course, this ended up being a much longer show than what I was expecting to put on. But with that show, or with all of that said, and having gone through this full update and having gone through all of this, we're going to leave it at here. Let's see what Flash fan has to say. A lot of people misinterpret because you're at trial. Yes, that is correct. They do. They absolutely do. And thank you, Sarah. I appreciate you. Thank you very much. And I will let her know congratulations. Yes, for the baby. She's, like I said, she's in that final 2 months now where it's starting to get a little bit uncomfortable in there. She says, because the baby's kicking all around and she's a small, petite little lady. So that when our 4-year-old, the last 2 months were really rough on her because it's just like, they don't have a lot of space, but oh, that's okay. That's okay. Flash fan. No problem on the misspellings. But yeah, I think so. You're saying a lot of people misinterpret because you're at trial. Yeah, well, yeah, absolutely. And they think you're guilty. Yeah, absolutely, they do. I mean, that's a common thing. But that's why, in my opinion, okay. And my dad was a big proponent of this. So a lot of what I'm telling you, I'm getting from my dad, who was a very successful attorney who tried 106 felony cases. Okay, he tried 106 felony cases, and he won not guilty. Okay. And I have his list of cases somewhere where I'll show him. And I believe he won 78 out of 106 felony cases. Not guilty, which is an incredible amount of wins. These are not, that's not misdemeanor cases. These are felony cases, murders, robberies, sexual assaults, all that stuff. Over his career. Now he's tried thousands of cases if you count DUI cases and magistrate court cases and stuff like that. But we're talking about felony serious cases. He did 106 cases and won 78 not guilties. And then the other cases, he only had 10 straight guilties. The rest were lessers, where they were found guilty of lessers, but he had 78 straight not guilties. That was, and like I said, I have his list of cases. He kept it on a little piece of paper, a little notebook piece of paper. But I can tell you, one of the reasons why he believed he always, first of all, the defense should never commit to anything. Okay. Because you don't have a burden. So the first thing you want to do is you want to make that. That's why when you have your opening statement needs to be talking about the fact that the state is here to prove, talking about that it's the state's burden to prove the defendant guilty. He's presumed innocent, regardless of what you hear, and regardless of what you might have heard on TV. We're not after this is not some search for the truth. The search for the truth happened in the criminal investigation. This is a review of the case that the state is bringing to you, which they claim they have proof beyond a reasonable doubt of the individual, of the accused. And we're here today taking this to trial because we believe there are questions, and we believe the state doesn't actually have proof beyond a reasonable doubt. And the standard here is not saying did he do it or didn't he? It's whether the state can prove beyond a reasonable doubt, a doubt based in a reason. And if there is even one doubt at the end of the case, you need to find the accused not guilty. And that's what we're going to talk about. Now, to getting into specifics, getting into what you intend to prove, the defense should never do that. They should keep it minimal. They should talk about the burden of proof and what they intend to do, and make sure the jury understands the framework of which to review things. Thank you, Sarah. Yes. Thanks for the update. I feel for your wife. I'm 4'10". The last 2 months is a struggle. My oldest is, yep. And my youngest is 4. It's never easier. No, and like I said, she's starting to feel it. And the last one, or our 4-year-old, she was in labor for, oh God, she was in labor for 26 hours, but she was pushing for 11 hours straight. And it was, she ended up, she should have had a C-section with the child, but they pushed, she ended up pushing him out, but unfortunately she had severe nerve damage, and she couldn't walk for 3 months, and that was very upsetting for her because it affected her ability to hold the baby, carry the baby, and she was out of work for much longer than what she should have been. She had to go through physical therapy and nerve conduction to get back. So this time we're going to be having a C-section. This go around, that was already established because they don't want to even try to attempt to go through what we went through with our 4-year-old. But yeah, we're getting into the fun of it now for her. It's going to be the rough time. So he says, I wish Ty all the best. I hope he gets an attorney and can walk free. Oh, absolutely. I do too. And do you think Ty should have testified? I don't think he hurt himself testifying, but I think that he walked into some areas. Do I think he should have testified? No, I don't. Because again, I don't think he needed to, but see, he got all worked up and believed he had to testify because of this whole knife. He got baited into testifying, and then they had a plan for that, and the plan was that's how they got the Facebook messages in. Okay, and they read that information in about the knife, and Ty said, "Well, I have to testify now," but he couldn't testify because guess what? He couldn't even talk about going down to the police station because they wouldn't let him talk about what occurred at the police station or what he was told by Phelps, because that was considered hearsay. And then they wouldn't let him play they won't let you play your police statement because you can't put forth prior consistent statements. The only way it comes in is if they want to impeach him with it. So it was an unnecessary move, but it did, in my opinion, with how well he testified, showed me that he's innocent, because an innocent man, only an innocent person could have testified under the circumstances he did and performed as well as he did. 26. You were 26. Yeah. Well, it was, like I said, I'm hoping we have a different one this time because, whew, it was brutal. It was. So fingers crossed on all of that. But yeah, that's where we're going to leave it. So I will, like I said, I've got a whole lot to catch up on. We've got to get Karen Reed caught up on. There is the hearing I want to play, which I have the hearing from the 11th Circuit Court. I want to play that for everybody. So we're going to probably do soon, maybe tomorrow night, we'll do another Justice Watch Live. I really want to get into the closing arguments because I think that's extremely relevant and it's extremely helpful. So we're gonna figure that out, which one we're gonna do first, and then like I said, we've got to get caught up on the Karen Reed case, and we're gonna do some Justice Watch lives on that as well, and then we've got the Gregor case that I've got to catch up on. That's one that we're doing after hours coverage of that. So we've got like day 7 and 8, and I know coming up, I think tomorrow they're going to do the final witness and closing arguments will be coming up in that case. So we've got some stuff to catch up with that, and then we've got on the other channel. Remember, everyone, if you weren't here at the beginning, I explained that we do have a new channel. Which one is that, Flash Fan? You're talking about the Gregor case? The Gregor case is not over yet. It's kind of interesting. The state has a witness. It's a doctor. It's a medical witness that they said they need to call. And essentially what they agreed to do was essentially the defense put on a couple of witnesses, but the defense agreed to hold off on putting any medical witnesses forward until the state could put their final medical witness on. So the defense opened its case, presented its case to the jury, and then there was like a period of time. That's why nothing's been going on with it. I believe tomorrow the state will be, it's either tomorrow or Tuesday, the state is going to put that witness on. Following that witness, the defense will put on its medical people, and then they're going to rest. And it's expected that the case will, the court will be in recess on, I believe, Thursday, Friday, and Monday. So I believe next Tuesday they will closing arguments will be scheduled Tuesday after Memorial Day, and they'll have the charge conference, and it'll be to the jury next week. But it's kind of a weird situation that they have going on in that case. But anyways, as I was saying, guys, head over to, there's a link in the there's a link there in the chat. It's pinned. I was trying to dual stream, but it didn't work out for whatever reason. I got to investigate why. But use that link to get over to my new channel, Justice Watch. And the purpose of that channel, as you know, this is Justice as a Process, is meant to follow current cases moving through the justice system, live time. Justice Watch is going to be about past cases. We're going to be digging into cases from the 90s, from early 2000s. I've got access to a library of cases. I'm going to be bringing it to you. We're going to be watching them. It'll be a slower format, and we're going to be taking on those cases. My goal is to show this podcast, this show, the main show that is meant for both of channels. I want to air them on both channels. But Ko-fi.com, which is the official site for Justice as a Process, or we're just called the Justice Watching community, the Justice Watch community, I will be posting schedules and trials and all information about both sites on Ko-fi.com. And of course, I will post links to those posts in the community sections on both that apply for both channels. So head over to Ko-fi.com. Flash Fan, it's funny. Yes, that is one of the cases I'm going to be covering. Yes. Alan Jackson was the prosecutor on that. Yes. Now, unfortunately, they did not do the second Phil Spector case. Okay, that was not televised. But yes, I have access to the first Phil Spector case, and I am going to be airing that. It's going to be a long one. I think it's like 78 or 79 witnesses or whatever. I mean, it's a lot of witnesses. It's going to be, but yes, that is one that is up. When we get done, in fact, I might go into that case first. I was considering it. I was trying to decide if I wanted to cover the O.J. Simpson Vegas case first or the Phil Spector case. And then there was also the Christy, I believe it's Christy Martin. She's a boxer whose husband stabbed her. That's a shorter case. I was considering one of those three to pull as the next case. But you requesting Phil Spector very well might make that the next case on that channel that we're going to cover. Like I said, it's going to be a slower format. It's not going to be as fast. We're going to be covering it witness by witness. And talking about it, and I'll show it, and I want it to kind of be, like I said, a more interactive approach on that channel, where we're going to be doing, and we're going to dedicate some episodes to it. So if we're covering a case over there, we're doing an episode like I'm doing covering Ty. There's going to be future Justice Watch lives about Karen Reed, and there will be ones about the case that we're covering over there. So stay tuned. But yes, absolutely. But get over there, get yourself subscribed, connect and follow at coffee.com. We're on Twitter as well. Go over and subscribe to Justice is a Process on Twitter. And that way you will be fully connected, so you know what we're doing, what cases we're following, and any updates, especially with Ty Tucker. I will keep you abreast of them as I find out, and we'll go from there. And then, hopefully, also we're on Rumble as well. So check us out on Rumble. I've actually got to figure out how to set up a subsidiary for Justice Watch on Rumble. Right now, Justice is a Process is the only thing on Rumble, but head over there as well. Get yourself followed on Rumble. We're fully monetized over there, so it's a great way to help support the channel and keep us going. Because we get full monetization. It's not as big of a platform as YouTube, but I'm hoping we get our full monetization back on Justice is a Process in July, and then we can have dual channels monetized. If not, we may have to reconfigure things. But I'm free to get another channel monetized connected to Justice is a Process. It's my understanding from reviewing the legalities after that initial 90-day period that I'm on right now to get all that worked out and back. But we'll see how it goes. So with that said, guys, I appreciate everyone who's watched. Make sure there's no other outstanding questions out there. And if there isn't, then I think what we're going to do is we're going to call it, because it's late and I did not intend necessarily to be on this long. But you know what? When you're covering a case like Ty Tucker's and you got all these things to talk about, sometimes you go it. So I hope to possibly be back on tomorrow night with a show. I've got to decide what the topic of that will be. I'm going to be airing, I think, day 14 tomorrow for Karen Reed. It's a half week, so I'm going to be behind the live. I don't expect a whole lot of people to jump in, but if you don't mind, come in, say hi, hit the like button, and move on. I'll be watching it tomorrow as I'm going about my business and getting caught up. And then we may run tomorrow's right after it, because I'm going to try to run it through and get us caught up if we can, and get fully caught up tomorrow. And I believe, if I recall the judge's schedule, they will have a half day of court on Tuesday. I believe Wednesday there is a full day of court, and then Thursday, Friday, and Monday there is no court on Karen Reed. So I believe that's what I recall. And of course, we'll also get caught up on the Gregor case. Anyways, with that said, guys, appreciate y'all, and I'll see you guys later. And thank you, Flash Fan. I agree, it was a good convo. I appreciate everybody that contributed, and I'll talk to you soon. Till then, guys, let justice prevail, and I'll keep you guys updated on what's going on with Ty as I get the information. Talk to you soon.
Slow up, no, I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast, I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past. And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you You know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains at last, and to believe in what you got, it was built to last, yeah. Now that I've been put through hell, I never got anyone's help. I had to do it all myself. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some honestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead of say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable. Thoughts in my head, a collage and they spread. I'll be great one day, going off of my meds. No, I'm not giving up, no, I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages. A vacant, modern kingdom for the taking. Now that I've been put through hell, I never got anyone's help. I had to do it all myself. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up